Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope today will be the day that I earn your subscription. For today's live content, we are doing something that we finally found some time for. I've wanted to do this for quite a while, but it's been busy. This is the case of the New York State Pistol and Rifle Association versus Bruen, coming out of the state of New York. This is being argued before the United States Supreme Court and was argued on the 3rd, 11 days ago. So I'm a little bit late to the party on covering this, but things have been busy and there was some traveling along the way, so things have been tough. But we finally found some time to actually do this thing, so let me read you the brief description from Oyez. The facts of the case are this. The state of New York requires a person to show a special need for self-protection to receive an unrestricted license to carry a concealed firearm outside the home. Robert Nash and Brandon Koch challenged the law after New York rejected their concealed carry applications based on failure to show proper cause, and that's in quote, proper cause, that's the part of the statute. A district court dismissed their claims, and the United States Court of Appeals for the Second Circuit affirmed. Thus, the question presented: does New York law requiring that applicants for unrestricted concealed carry licenses demonstrate a special need for self-defense violate the Second Amendment? So, just a little bit more about that. New York State, and not very many other states, but California is also a notable one, are what's called may issue. That means that New York only issues concealed carry permits to people if they meet certain criteria, as opposed to issuing them to everybody who meets the standards as a matter of law. So for most states, for example, you just have to, well, it depends on your state, to be quite honest, but a typical thing would be to have some sort of safety class, to pay a fee, to fill out a form. And if you do all those things, and it's usually not very much in most states, but if you do all those things, you have a license to conceal carry. And this license to conceal carry applies, except of course where it doesn't, and then of course you have to go to specific state law for that. So New York State issues a couple different kinds of permits. They issue what's called a premise permit, which allows you to have a firearm on your premise, whether that's at your house or at your work. And they do also technically issue carry permits, which allows you to carry. And the issue here is that these people want what they're calling unrestricted, although that's a bit of a bad name for it, because they would be restricted by other aspects of law. It's just that they don't have any special hoops on them. So New York State doesn't issue it. You have to show what they call proper cause, which is a special reason. So it's not enough for you to want one for self-protection, because that's not a special reason. Everyone might want special self-defense. So you have to essentially, as a matter of practice, show some special threat to you that doesn't apply to the average, normal, ordinary person. So basically, by definition, therefore, the average, ordinary, normal person cannot get a concealed carry permit in New York. You have to be special, definitionally, unlike many states. So yeah, New York says you have to be special, and they don't think very many people are special. So the question is, do you have to be special? Or can just anyone get one of these things as long as they meet other criteria? You know, go through the background check, show some sort of basic competence, whatever. And then we, of course, in later cases that would follow this, we'd get into what kind of requirements are legal, right? So can they make you take this kind of a safety course instead of this kind of a safety course? Can they make you pay this fee instead of that fee, right? We could get into particulars about what kind of things are required, but we haven't even gotten that far. Because even if you did all those things, you still need to show this special reason. So do you need to show the special reason on top of whatever else might be legal? That's the question we're trying to solve at the moment. Okay, great. So we're going to listen to this oral argument. It's 2 hours long. And we're going to listen to this and we're going to comment along the way. So this should be very interesting. And I hope you'll find it as interesting as I do as well. So let's go on with all that.
We will hear argument this morning in Case 2843, New York State Rifle and Pistol Association versus Bruen. Mr. Clement.
Mr. Chief Justice, and may it please the Court, the text of the Second Amendment enshrines a right not just to keep arms, but to bear them. And the relevant history and tradition, exhaustively surveyed by this Court in the Heller decision, confirm that the text protects an individual right to carry firearms outside the home for purposes of self-defense. Indeed, that history is so clear that New York no longer contests that carrying a handgun outside of the home for purposes of self-defense is constitutionally protected activity. But that concession dooms New York's law, which makes it a crime for a typical law-abiding New Yorker to exercise that constitutional right. This court in Heller labeled the very few comparable laws that restricted all outlets for carrying firearms outside the home for self-defense outliers that were rightly condemned in decisions like Nunn against Georgia. New York likens its law to a restriction on weapons in sensitive places. But the difference between a sensitive place law and New York's regime is fundamental. It is the difference between regulating constitutionally protected activity and attempting to convert a fundamental constitutional right into a privilege that can only be enjoined by those who can demonstrate to the satisfaction of a government official that they have an atypical need for the exercise of that right. That is not how constitutional rights work. Carrying a firearm outside the home is a fundamental constitutional right. It is not some extraordinary action that requires an extraordinary demonstration of need. Petitioners here seek nothing more than their fellow citizens in 43 other states already enjoy, and those states include some of the most populous cities in the country. Those states, like New York, limit the firearms in sensitive places, but do not prohibit carrying for self-defense in any location typically open to the general public. I'm happy to continue by point.
Okay, so far it is a fine opening because this is Paul Clement, and Paul Clement is one of the best U.S. Supreme Court attorneys that exist. It's a short list, and Paul Clement is definitely one of the best. So it is no surprise that we're getting a really good, outstanding argument from Paul Clement. He's definitely one of the guys. He's one of the best guys you can possibly get as a Supreme Court advocate. It's who we all hope to be when we grow up. So Paul Clement knows his shit. So yeah, he raises the case very easily. You know, this is going on in 43 states, and the problem is that New York doesn't allow you to carry firearms in general, right? Whatever sensitive places are, and we could have a discussion over that, the very term sensitive place implies there's such a thing as a non-sensitive place, right? You can't have sensitive places unless you have non-sensitive places, because otherwise it doesn't make any sense. So New York says, well, it's a regulation of sensitive places. It's a little bit hard when all the places are sensitive. Doesn't really quite work. So they say, yeah, this is whatever this right is and whatever its confines are, whatever the scope of the Second Amendment is, it's not something that you should have a special need for. This is analogous to any other right in the Constitution, like the First Amendment, for example. The First Amendment has its confines and its boundaries and its limitations. This goes well back into law that exists like basically forever. But whatever the scope of that right, whatever the boundaries of that right are, they exist for everybody. You don't need to have some special need to exercise a First Amendment right. That'd be kind of dumb. Or a Fourth Amendment right, or literally basically any other right in the Constitution. So whatever the right to bear arms is, the idea that you have to show a special need for it doesn't seem to flow. So that's a very strong opening argument. It's exactly what you'd expect from Paul Clement. Let's listen more.
Mr. Clement, sorry to interrupt you. If we analyze this and use history, tradition, text of the Second Amendment, we're going to have to do it by analogy. So can you give me a regulation in history that is a basis that would form a basis for legitimate regulation today? If we're going to do it by analogy, what would we analogize it to? What would that look like?
Well, Your Honor, I suppose if you're going to reason by analogy, then you could, go back and you could find analogous restrictions relatively early in our nation's history about prohibiting certain types of firearms or having firearms or any weapon really, in certain sensitive locations. And I think you could reason in that way. Here, I think the reasoning works the opposite direction, which is you typically have a baseline right to carry for self-defense. And the only historical analogs that really restricted the right of a typical law-abiding citizen to carry for self-defense to the same degree as the New York law here were those laws, very few, typically post-Reconstruction laws, that purported to eliminate any right to carry openly or concealed. And those laws were essentially invalidated by every court that was applying an individual rights view of the Second Amendment. And those decisions, of course, were exhaustively considered by this court in Heller. And those decisions were praised for their understanding of the Second Amendment and the relationship between the prefatory clause and the operative clause. And equally important, those laws were set forth by this court and singled out by this court as the very few restrictions historically that were comparable to what the District of Columbia was doing in Heller.
So if we look at you mentioned the founding and you mentioned post-Reconstruction, but if we are to analyze this based upon the history or tradition, should we look at the founding or should we look at the time of the adoption of the 14th Amendment, which then, of course, applies it to the states?
So the answer here basically has to be, whatever the answer, it has to be the original Constitution. You go back to the Bill of Rights. And the reason here is because what Justice Thomas is basically asking is what should we do, a two-track thing? So should we do this as two-track? Which has been rejected by the Supreme Court in every single application it's ever come up, ever. So what I mean by two-track is that the First Amendment, this is by analogy, but the First Amendment would mean something different when it comes to the federal government than it comes to the states. This is the idea, right? Because the 14th Amendment is the one that incorporates the First Amendment. So there's this idea, okay, when it incorporated the First Amendment, for example, did it incorporate it as is, or does it incorporate it as it then existed at the time of the 14th Amendment, right? So maybe the 14th Amendment changed the meaning or understanding of the First Amendment. So the First Amendment would have a different understanding for the federal government than it would for the states' governments. And that could, of course, go both ways. I mean, it's not necessarily like it being more or less, because you'd have to go analyze it at the time. So when it became incorporated, maybe it's more, maybe it's less, but the idea is it's different. Yeah, no, they've rejected that in every single application that's come up. No, we don't do the two-track thing. It's been rejected full hog. Whatever the Second Amendment means, or pretty much any other provision of the Constitution for that matter, whatever it means the same thing that does for both sets of governments. So we don't have to worry about that problem. So yeah, he's asking a two-track question, which is strange because we don't do that.
So, Justice Thomas, I suppose if there were a case where there was a contradiction between those two, and the case arose in the states, I would think there would be a decent argument for looking at the history at the time of Reconstruction, and giving preference to that over the founding. I think for this case and for Heller, and I think for most of the cases that will arise, I don't know that the original founding history is going to be radically different from that at Reconstruction. But I guess what I would say is I do think that's about where it stops, because the point here isn't to look at history for the sake of studying history. The point is to look at the history that's relevant for understanding the original public meaning of the Second Amendment and the 14th Amendment.
Mr. Clement, how could it stop there? In Heller, we made very clear that laws that restricted felons from carrying or possessing arms, and laws that forbade mentally ill people from doing the same, we basically put the stamp of approval on those laws, and those laws really came about in the 1920s, didn't they?
Justice Kagan, I think some of those laws in their current form took that shape in the 1920s, but I also think there was a tradition from the beginning for keeping certain people outside of the group of people that were eligible for possession of firearms. I think obviously there was a different tradition with respect to felons, in part because, you start at the time of the framing, and most felonies are capital crimes. So, the need to disenfranchise felons for firearm possession was a little different at the framing. So I think you do
This is a very good point. You don't really have to talk about whether or not felons at the time of founding should be denied their right to keep and bear arms, because at the time of the founding, all felonies were death penalty. So that kind of solved that problem.
To make those kind of adjustments. But I think those adjustments can be made. I think really there are two reasons to at least be skeptical of post-1871 history. I mean, the first is I just don't really understand why it's terribly relevant in forming the original public meaning of the Constitution. But, of course, the second reason is it's just about that time that the collective rights view started to creep into the decisions of some state Supreme Courts. And I think so in Heller's a perfect example that this Court didn't absolutely stop its analysis in 1871, but when it looked at those later sort of post-bellum state Supreme Court decisions, the ones that relied on a collective rights view were given very short shrift. And I think that's the appropriate way to sort of deal with these historical analogs.
Well, I have two questions. One is on history. I mean, its law is history. In McDonald, we had professors of history who ran departments in the English Civil War, and they all said the history in Heller was wrong. You've read the briefs here. I don't know. You read the briefs of the historian of the Air Force, and she says it's this way, and the other one says it's the other way. How are we supposed to deal with that? There's a good case. This is a wonderful case for showing both sides. So I'm not sure how to deal with the history. My other question is I'm not sure what New York does. We're talking here about outside New York City. New York says we have about 90,000 licenses to carry concealed weapons, or maybe it's 40,000, or maybe it's 10,000. But there's been no trial. There's been no proceeding. All it is dismissal on the. So how are we supposed to find out, A, what the history is, which is my minor question, really. There's a lot of debate on that. But second, how are we supposed to know what we're talking about in terms of what New York does, since they say they give, including to one of your clients, they give a license to carry a concealed weapon. So there are concealed weapon licenses all over the place. So what are we supposed to do about those two things?
Well, Justice Breyer, let me start with the major question, which is, because I think that's actually very straightforwardly answered, which is there's no serious question about the experience of the individual petitioners in this case. And they both sought unrestricted licenses, and they were both denied unrestricted licenses, notwithstanding that they satisfy every other requirement that the state has to be licensed for concealed carry. And so I'm happy to debate why the state statistics don't really prove anything particularly relevant, but I think they're irrelevant for a more fundamental reason. I mean, if there were a debate between the parties about whether 95% or 90% of the citizens of New York were denied their confrontation rights in criminal trials, but you had before you two individuals who were clearly denied the right to confront the witnesses against them, you wouldn't worry about the other 95% or the other 90%.
That's a really great answer. I like this answer, and that's why Paul Clement is the best. He's one of the OGs, right? So how many concealed carry permit licenses are there in New York? Well, Breyer doesn't seem to know. But Paul Clement says it doesn't really matter now, does it? Because New York could be issuing concealed carry permits to literally every single citizen of New York other than my clients, and we'd still have a case, which is right. Because if it's a constitutional right, it's a constitutional right. So if we give everyone the right to confront their witnesses but the one guy has a pretty good argument on appeal now, doesn't he? So it doesn't really matter how many people we give the right to confront witnesses. It doesn't really matter how many people we give the right to give freedom of speech. If we deny it to one guy in an unlawful way, well, it's unlawful. So yeah, Justice Breyer, these permits may in fact exist all over the place. I know they don't, but let's just assume they do. Does it really matter? Nope, not for my guys. It doesn't. Great answer.
That's not really the way your brief is written. The way your brief is written is to say, this is a regulatory scheme that deprives most people of the right to carry arms in self-defense. And your brief puts a lot of emphasis on that. Like, don't believe the state that they're going to really take seriously people's need for self-defense because they always reject these licenses. if you had a bunch of statistics which suggests that the state is quite sensitive to people's need for self-defense and gives these licenses a significant amount of the time, you might think differently about the regulatory scheme, wouldn't you? I mean, that's the way your brief reads to me.
Well, Justice Kagan, 2 points. One is I wouldn't feel any differently with respect to my 2 individual clients who were denied their right to exercise their Second Amendment rights. But more broadly, the reason I'm so confident that this regime is problematic on its face is because on its face, at least as interpreted by the highest court in New York, the requirement you need to show in order to carry concealed for self-defense, but not for hunting and target practice, is you have to show that you have a need for self-defense that distinguishes you from the generalized community, from the general community. So New York's law on its face says that the only way that you can carry for self-defense is if you demonstrate your atypicality with respect to your need for self-defense.
Damn straight.
And that's
because, look, Mr. Koch can. He has his license. He can carry it for self-defense under the license to and from work. And as you say, he can carry it for hunting, target practice, etc. Concealed. And in your opinion, is it supposed to say you can carry a concealed gun around the streets of the town or outside just for fun? I mean, they are dangerous guns. I mean, so what's it supposed to say?
It's supposed to be what New York says that they give to lots of applicants, at least in other counties, which is an unrestricted license, which basically means that somebody who has demonstrated to the state that they're of good moral character, that they have all the necessary training, whatever the state requires.
40,000 or 50,000 or 60,000 is not enough. You have to show you have a good moral character, and then if you just would like to carry a concealed weapon, which is a dangerous thing, as I said, you can just do it. That's what that's, in your opinion, that's what you want. No restrictions.
Well, certainly New York is entitled to have laws that say that you can't have weapons in sensitive places, in addition to whatever regulation.
I'm not saying
right. And New York has those laws, and we don't challenge those. What we're asking for, I mean, one way to think about it is we're asking that the regime work the same way for self-defense as it does for hunting. When my clients go in and ask for a license to concealed carry for hunting purposes, what they have to tell the state is they have an intent to go hunting. They don't have to say, I have a really good reason to go hunting. I don't have to say, I have a better reason to go hunting than anybody else in my general community.
Well, the difference, of course, you have a concealed weapon to go hunting. You're out with an intent to shoot, say, a deer or a rabbit, which has its problems. But here, when you have a self-defense just for whatever you want to carry a concealed weapon, you go shooting it around and somebody gets killed.
With respect, Justice Breyer, that's not been the experience in the 43 jurisdictions that allow their citizens to have the same rights that my clients are looking for. This is not something.
So I think we can pretty well determine over here which way Justice Breyer is leaning. Doesn't seem to be the hugest fan of the concealed carry over here, because people will go about concealed carry and will just start shooting each other all the time. So they just because they could just carry it, for the hell of it, and that'd be really dangerous. I think we can see which way Justice Breyer is heading on this one.
Where we're asking you to take some brave new experiment that no jurisdiction in Anglo-American history has ever
Mr.
done.
Clement, may I? You're talking about 43 other jurisdictions, and I suspect that when we get into those 43 other jurisdictions, that they're going to be a handful that are identical. The one thing that I've looked at in this history is the plethora of regimes that states pick. And that starts in English law, through the colonies, through post-Constitution to post-Civil War to the 19th century to even now. Those 43 states that you're talking about, most of them didn't give unrestricted rights to carry in one form or another until recent times. Before recent times, there were so many different regulations. What it appears to me is that the history, tradition, of carrying weapons is that states get a lot of deference on this. And the one deference that you haven't addressed is the question presented is, what's the law with respect to concealed weapons? In 1350, the British Parliament specifically banned the carrying of concealed arms. In colonial America, at least 4, if not 5 states restricted concealed arms. After the Civil War, there were many, many more states, some included in their constitution, that you can have a right to arms but not concealed. You can go to Alabama, Georgia, and Louisiana, which are now more open, are more free in granting the right to carry guns, but they prohibited, through their history, concealed weapons, the carrying of concealed weapons. It seems to me that if we're looking at that history and tradition with respect to concealed arms, that there is not the same requirement that there is in the home. One of the things Heller pointed to was there were few regulations that prohibited the carrying or the keeping of arms in homes. But that's not true with respect to the regulations about keeping of arms outside of homes. Putting aside the prohibitions, regulations on sensitive places, regulations on the types of people, it seems to me that I don't know how I get past all that history without you sort of making it up and saying there's a right to control states that has never been exercised in the entire history of the United States as to how far they can go in saying this poses a danger.
Yeah, as Paul Clement's about to get into, this is a fairly accurate summary of the history of it, as I understand. It is most states, well, that's not fair. A lot of states banned concealed carry and allowed open carry, and you can definitely find cases in the earlier constitutional history which talk about this aspect. And there's a lot of cases, well, I don't know if there's a lot, but there's a number of cases that uphold bans on concealed carry, but they all had open carry. So this is a fair critique that, maybe the right to bear doesn't speak to concealed carry. Maybe it only speaks to open carry, which it might very well be. So Paul Clement's about to try to answer this question, so it should be entertaining.
So, Justice Sotomayor, there's a lot to that question. I'll try to take it, sequentially if I can. Let's start with concealed carry restrictions. It is true that during
I like what someone in chat said. Hines here said history. Back in olden times, you used to be able to own people. Olden times doesn't necessarily mean correct or incorrect. Well, it's law. Not to put too fine a point on it, but we passed the constitutional amendment to prevent people from owning people because we realized it was a mistake. So, but if you're trying to understand the scope of the Second Amendment, then going to history and trying to understand what the right to keep and bear arms is, that's what you would do. So, yeah. You can repeal the Second Amendment. You just have to pass the constitutional amendment. We repealed the 18th Amendment with the 21st. So, go nuts. Good luck.
Time periods where open carry was allowed, that some states did specifically restrict concealed carry on the precise theory that if we allow you to carry open, then if you're carrying concealed, you're probably up to no good. And Heller did exhaustively survey those cases. And what it concluded is that if a state allows open carry, then it can prohibit concealed carry. I suppose vice versa.
But you're asking us to make the choice for the legislature. We're only looking at concealed here.
We are not asking you to make that. And
well, you are, because you're conditioning history on a different fact.
I don't think we're asking for anybody to make that choice. In fact, the relief we've asked for is to have an unrestricted license because under New York law, as it currently exists, that's the only way that you can have a carry right for a handgun. But in framing our relief in the complaint, we framed it so that there are other relief consistent with the decision. So if New York really wanted to say, no, we have a particular problem with concealed carry, notwithstanding that traditionally that's the only way we allow people to carry. If they want to shift to an open carry regime, they could do that consistent with everything we've said here. Now, I don't think anybody expects that to happen because if you look at the New York law specifically, it's a law that prohibits the carrying of handguns except for permit holders. And then its provisions about permit holders speak specifically to concealed carry. So that's why we've framed our request the way we have. But what we're doing, I think, is completely consistent with the majority decision in Heller's analysis of the historical cases, which said that those very few states that tried to prohibit both concealed carry and open carry and so gave no outlet for the right to carry a firearm for self-defense outside the home, those were the laws that the Heller majority identified as being analogous to the D.C. restriction in Heller that was invalidated.
I do know that many of the laws conditioned or retain the right of the state to decide which people were eligible. And the historians to carry the arms, that you had to be subject to the approval of the local sheriff or the local mayor, etc. And during the Civil War, that was used to deny black people the right to hold arms. We now have the 14th Amendment to protect that. But why is a good cause requirement any different than that discretion that was given to local officials to deny the carrying of firearms to people that they thought it was inappropriate, whether it was the mentally ill or any other qualification? That's how I see the good cause, as fitting in within that tradition.
So let me make a point about how it's so different from that tradition, but then also let me make a historical point. It's radically different to say that if you are a typical New Yorker, so you satisfy every other qualification, you're not a felon, you don't have any mental health problems, you've done everything else we've asked you, but you are typical in the sense that you don't have an atypical need to carry for self-defense. Mm-hmm. I don't think there's any historical analog to that. As to the historical examples, with all due respect,
very, very good. Very, very nice answer and very good way to solve this problem, right? So Justice Sotomayor is saying that some of these restrictions are relatively new in time. She made this point earlier about saying some of these restrictions only are since the 1920s. But Paul Clement here is like, well, we can analogize it to other kind of restrictions that were available at the time. So maybe these kinds of restrictions are new, but they're at least analogous. And we often reason by analogy in law. But there's nothing like, you're a totally qualified person, but you just are not, you don't have a special need. There's nothing like that in the historical record. I think he's right, and it's a very good answer. Nice way to address Sotomayor's question.
I don't think I read the surety laws the same way that you do. Those surety laws, which were only in place in a minority of jurisdictions, but nonetheless, I think they help us. Because those surety laws, first of all, start with the proposition that there's a baseline right for every person, every member of the people protected by the Second Amendment to carry. And what they do is if somebody essentially as a complainant can come into court and say that somebody has a propensity to use them in an offensive or violent way, then if you satisfy a neutral fact finder, then you don't automatically get to disarm that person. You put them to the choice of posting a surety, and then they can continue to possess their firearms.
Mr. Clement, in your opening, you talked about the right applying in any location typically open to the general public. I'd like to get some sense about what you believe could be off limits, like university campuses. Could they say you're not allowed to carry on a university campus?
So, Mr. Chief Justice, I think the answer to your question is yes. And I think that what I would say, though, first of all, is the language I was talking about, any location open to the general public, that's right from the license denial on Joint Appendix page 41. So there wasn't loose language on my part. That's right.
Good answer. Good answer. So, yeah, this any place open to the general public. He says, well, what about university campuses? And he just says, well, that's the language from their own denial. So they seem to think that if they give a permit, it's open anywhere open to the general public. So I'm not making that up. That's from New York. Very nice.
Right there from where we are told in capital letters where we cannot carry any location, all caps, typically open.
Well, what sort of place do you think they could be excluded from? In other words, you can get a permit, but the state can impose certain restrictions. For example, any place in which alcohol is served. So and they say you cannot carry your gun in any place where alcohol is served.
So, Mr. Chief Justice, I think probably the right way to look at those cases would be look at them case by case and say, okay, in this court in Heller, for example, said sensitive places include government buildings and schools. I think those you can probably tap into a pretty good tradition. I think any place that served alcohol would be a tougher case for the government. I think we would have a stronger case. They might be able to condition the license holder on not consuming any alcohol. There might be a variety of laws, and we could have those debates. But
what about the football stadium?
I think, again, football stadium, you'd probably take it on its own and look to the historical analogs. But here's, I guess, if I could offer some general principles. I think there's two principles. One is, restriction of access to the place is something that I think would be consistent with the way government buildings have worked and schools have worked. Not any member of the general public can come in there. They restrict access with or without a gun. If you're an adult that has no business to be in a school, you're excluded. So I think that's a factor that would support treating that as a sensitive place. A second principle that I would offer is these sensitive place restrictions really are a different animal than a carry restriction, because I think a true sensitive place restriction is not just going to limit your ability to carry concealed, but it's going to be, say, this is a place where no weapons are allowed. Whether they're firearms or other weapons, no weapons are allowed. And then the third point that I would say, and this is just an analogy, but I think it's a useful analogy, is I think the way to think about this is a little like the non-public forum doctrine in the First Amendment, which is you start with the place, and you try to understand, is this a place where, given the nature of the place, its function, its restrictions on access, that weapons are out of place? And if so, that's probably a sensitive place where the state can say.
But I think what the Chief Justice is trying to do is figure out how those cash out in the real world. So I'll give you a few more. New York City subways.
So, I think that the question of whether you could restrict arms in the subways, you'd have to go through the analysis, I think, and say, is there restriction on access generally? I suppose.
No, I got the analysis, okay. All three parts of it. Like, how does it cash out? What does it mean?
I don't know how those are going to cash out in particular cases, because I think the way that you would normally deal with that is you'd look at all the briefing we had in this case on the history of these various things. And so, on behalf of my individual clients, I suppose I could give away the subway because they're not looking to go, they're not in Manhattan, they're in Rensselaer County.
The Chief Justice started with universities, and you said that would be all right. Did you mean that?
Yeah, yes, I did mean that.
Because that's open for, anybody can walk around the NYU campus.
Well, NYU doesn't have much of a campus.
I would go back to New York, and I think you'll find that that's wrong. Similarly, the Columbia campus.
Columbia's got a campus, and I don't know whether they restrict access at all. And maybe, if they don't restrict access to parts of the campus, maybe those are parts of the campus where they wouldn't enforce the policy anyways. The point I'm trying to make,
But you can't say, there are 50,000 people in one place, a ballpark. There are 50,000 people in one place. They're all on top of each other. We don't want guns there. That's you couldn't the city or the state couldn't do that?
I think they might well be able to, because again, you can't get into Yankee Stadium without a ticket. I'd have to understand many of these, I don't know every jurisdiction. I don't know enough about Yankee Stadium, but, a lot of these stadiums are not run by the government anyway. So if a private entity wants to restrict access, I don't know where the state action is for there to be a second.
Suppose the state says, no protest or event that has more than 10,000 people.
I think that might be trickier. Maybe they could justify that under strict scrutiny, but I don't think that would be a sensitive places
But
restriction.
why not? I mean, I guess it's about the level of generality. All these questions that Justice Kagan's asking you or that the Chief asked you, if you concede, as I think the historical record requires you to, that states did outlaw guns in sensitive places, can't we just say Times Square on New Year's Eve is a sensitive place because now we've seen, people are on top of each other, we've had experience with violence, so we're making the judgment. It's a sensitive place.
So here's what I would suggest, that the right way to think about limiting guns in Times Square on New Year's Eve is not as a sensitive place, but as a time, place, and manner restriction.
I like this answer. I like this entire line of answers. Now, you have to understand, as I'm sure I hope many of you do, the underlying climate that Paul Clement has to deal with, right? The underlying climate is that the Supreme Court, for various reasons, and one could speculate, is that they have been very hesitant, as I'm sure many of you know, to take up any Second Amendment cases. There hasn't really been a prominent Second Amendment case since Heller and McDonald, and that was quite a long time ago. So they see whatever appetite there is to confront this question or grant a relief. Paul Clement has to be careful about not asking for too much. It's much better to get something and then fight for the rest another day. It's a very prudent approach, particularly when the Supreme Court has, if you overreach and the Supreme Court rules against you, you have a precedent against you, and good luck on being able to undo that. So you have to be a little bit cautious. So I think Paul Clement is very tactically smart here to be cautious. So they're asking him all these questions, and first of all, he demurs because he rightfully points out that each of them would have to be analyzed onto their own facts, and in a lot of cases they're not state actions, so there is an issue there. And then I really like his answer here because of the time, place analogy. He's reasoning by analogy to the First Amendment, which I think is a very, very good analogy. I have often stated that I think the First Amendment and Second Amendment are very similar in their language. And I think that we have quite a lot of First Amendment law, so I think reasoning by analogy to the First Amendment is a pretty good way to go. And so he's saying, okay, it's not that it's a sensitive place, it's a time, place, manner restriction. Okay, maybe. And I think he's on the right track. So I think Paul Clement's pretty damn smart. He knows his territory. So I think he's arguing very conservatively because he wants to make sure that he's not going to get any sort of adverse decision out of this court. So I think he's being very smart in that respect.
And that might be a perfectly reasonable time, place, and manner restriction. But I don't think that's the sensitive places doctrine as I understood it and obviously it's a brief reference in the Heller decision, so I may not fully understand it. But I understood that those were certain places where there were just no weapon zones all of the time because of the nature of that institution. And I think it's probably worth thinking about rallies and Times Square. There may be restrictions, but they would be done under the rubric of time, place, and manner.
Could we start with the purpose of the personal right to keep and bear arms? And the core purpose of that right, putting aside the military aspect, is self-defense. So starting with that, could we analyze the sensitive place question by asking whether this is a place where the state has taken alternative means to safeguard those who frequent that place? If it's a place like a courthouse, for example, a government building where everybody has to go through a magnetometer and there are security officials there, that would qualify as a sensitive place. Now, that doesn't provide a mechanical answer to every question, but would that be a way of beginning to analyze this?
Justice Alito, that might be a way of analyzing it. The reason I'm a little bit reluctant to go that route as opposed to really think about the nature of the place and the restrictions that are associated with its core activity is because I worry that if you went that direction, then the state would say, well, this part of the city, we have a lot of police officers, and so you really don't need to exercise your own individual self-defense right there because we have your back. And I don't think that's...
I don't know what those places would be, but continue.
Well, I think my friends would tell you that, the whole city of New York is that way. And I think there are a lot of people in New York, and New York may have a lot of reasons to have regulations that are a little bit different than in upstate New York, where my individual petitioners reside. But I don't think that they can take all those people in New York and deny them of their fundamental constitutional rights.
How do we do this?
Justice Breyer?
How? I mean, so far we've been, to my mind, I think NYU does have a campus. You're not certain. All right? You think that in New York City, people should have considerable freedom to carry concealed weapons. I think that people of good moral character who start drinking a lot and who may be there for a football game or some kind of soccer game can get pretty angry at each other. And if they each have a concealed weapon, who knows? And there are plenty of statistics in these briefs to show there are some people who do know. And a lot of people end up dead. Okay? So, what are we supposed to do? To sort of float around, like with NYU, and say, hey, this is the rule. It seems to work out in upstate New York. We don't know, of course, and we do know that your client is carrying a concealed weapon because he has a right to in some instances, and even following Heller and following the history, which I thought was wrong. Even so, what are we supposed to say, in your opinion, that is going to be clear enough that we will not produce a kind of gun-related chaos?
So, Justice Breyer, I would sort of point you to two things that maybe would give you some comfort. I mean, one is the experience of the 43 states, and there are amicus briefs on both sides getting into the empirical evidence, but there really isn't the case that those 43 states that include very large cities like Phoenix, like Houston, like Chicago, they have not had demonstrably worse problems with this than the 5 or 6 states that have the regime that New York has. So that's one place to look. The other place that I think you would find something persuasive there is their own amicus brief on their side by the city of Chicago. Because the city of Chicago is in a shall-issue jurisdiction. And the city of Chicago goes on to sort of, essentially brag about all of the ways that they've done consistent with that regime to reduce crime in Chicago that probably doesn't have a direct analog in downstate Illinois. But of course, one of the problems with this case.
I mean, most people think that Chicago is like the world's worst city with respect to gun violence, Mr. Clement.
Chicago and their corporate
Chicago doesn't think that, but everybody else thinks it about Chicago.
And nobody thinks that about Phoenix, and nobody thinks that about Houston, and nobody thinks that about Dallas, and nobody thinks that about San Diego, which, even though it's in a restricted state, is a shall-issue jurisdiction.
Thank you, Mr. Clement. Justice Thomas, anything further?
Mr. Clement, where does Mr. Nash live?
Mr. Nash lives in Rensselaer County, New York.
Is that close to NYU?
That is nowhere near NYU, Justice Thomas. And, I think if you look at the county website, they talk about their 153,000 people spread over 955 square miles. And yet that's the context in which my individual clients are being denied their Second Amendment rights.
Justice Breyer, anything further? Justice Alito? Justice Sotomayor?
Counselor, your client is permitted to, Mr. Nash, one of the two, to carry when engaged in outdoor activities of any kind, like camping, hunting, and fishing on back roads, with the few substantially lesser number of people. Tell me how many places in Rensselaer County does your client have a self-defense risk?
Well,
at what point do we look at the restriction and the burden it places? Meaning, yes, I'm sure it has a center of town. I'm sure it may have a shopping center or two. But it's not like he's totally restricted from carrying a gun. He's just restricted from carrying one basically in those sensitive places. because the rest of his home is pretty distant from other homes.
So, Justice Sotomayor, just so we start on the same wavelength or the same page, literally page 41 of the Joint Appendix, this tells Mr. Nash where he can carry concealed. And what the officer, McNally, told him was, quote, I emphasize that the restrictions are intended to prohibit, italicized, you from carrying concealed in any location, all caps, any location, typically open to and frequented by the general public. Now, I would submit that's a pretty broad number of places in Rensselaer County, and it would include, I fear.
Yeah, and any place open to the public, I think, would encompass pretty much all of Rensselaer County. If I had to take a friendly bet, that's pretty much all the places, except for someone's home, but just about anywhere else. So yeah, that's basically everywhere.
Most of the roads in the county at night when you're traveling and might think that you have a need. I mean, if Mr. Nash has a relative whose car breaks down and has to have a change of tire and he wants to go out and assist them with that and wants to make sure that he is in a position to defend himself, I don't think he can do it consistent with this license restriction. And at the end of the day, I think what it means to give somebody a constitutional right is that they don't have to satisfy a government official that they have a really good need to exercise it or they face atypical risks.
Truth bombs from Paul Clement. Nice answer there at the end in particular. I really like that answer. What it means to have a right is you don't have to convince the government it's good. So a little bit of very nice response there. This is why Paul Clement is awesome.
Justice Kagan, anything further?
Mr. Clement, you said, I think in passing, that it would be fine if New York banned open carry so long as it allowed concealed carry. Is that correct?
Certainly that's consistent with the relief we're looking for. We're looking for some outlet to exercise our constitutional right to carry firearms outside the home.
How is it consistent with the history? I mean, the history seems very clear to me that it's sort of like the exact opposite of how we think about it now. In other words, that there are lots of places that wanted people to display their arms as a matter of transparency, and what they prohibited was the concealed carry. So I'm thinking, like, if you look to the history, you end up with a completely different set of rules from the ones that you're suggesting with respect to concealed versus open. And it's an example, I think, of the difficulties of looking to history, where people were operating on such different, to use your term, wavelengths.
So, Justice Kagan, first of all, I would have thought that, we'd sort of cross the bridge to use history in this context in Heller. But if we're going to look to history, I actually think
Mr. Clement, the question is how to use history. And, where do you look? How far do you look? Do you look to the 1920s when all these felon laws were passed, as well as public purpose laws of exactly the same kind as New York? So one question is how far up do you look? Another question is, with what sense of flexibility do you look? And I think that this is an example of that. It's like, no, we're not going to ask for an exact analog because we realize that the world has changed and regulatory schemes are very different because regulatory interests are very different. If we tried to copy history, we would find ourselves in a world in which the only thing that a state could do is tell people, you can't carry it concealed, you have to carry it open.
So, Justice Kagan, let me give you an example of how I think the Court should use history in this context. And I'll go exactly to the Georgia statute that was at issue in Nunn against Georgia. Now, that was a statute that on its face prohibited carrying simpliciter. So it didn't say open, it didn't say concealed. Now, the court that analyzed that reversed, vacated the indictment of somebody under the statute, because the statute didn't specify and they didn't think that person had carried concealed. But when they looked at it, they interpreted it in light of the context at the time, and they thought, boy, it is not consistent with the Second Amendment that that court actually thought directly applied to the state, which is interesting. But they said that's not consistent with the Second Amendment to prohibit any means for carrying. Then, consistent with kind of the norms of the time, kind of almost as like a severability holding, dare I say it, they said, well, all right, the open carry, that's allowed. I mean, rather, that's we're going to say that to the extent this statute prohibits open carry, that's unconstitutional, but to the extent that it prohibits concealed carry, that's constitutional. Now, the fundamental problem with the law that carries over as a direct analogy is it gave no outlet to exercise the constitutional right to carry for self-defense. The norms of the time had a favoring for open carry over concealed. I will grant you that the norms of the time have flipped, and certainly in New York, based on the rest of their licensing regime, I assume that they would prefer that my clients carry concealed rather than openly. But I think that's the way you can use the history, and you can use it with some contextual sensitivity, but you cannot sort of, throw it all out, because I do think the analogy is pretty clean between a law that prohibits any form of carry and what New York is doing here. And, of course, that was one of the laws that this court specifically looked to in the Heller decision as well.
And when you look at this history in the properly contextual way, do you see no difference between the kind of regulation that was allowed in the home and the kind of regulation that was allowed in public places? Because it seems to me that the history, and Justice Sotomayor developed it at some length, but the history is replete with that distinction. And indeed, Heller recognizes that. Heller recognizes that the home is a very special place, both because, for similar reasons for the Fourth Amendment, but also because the need for self-defense is so much greater there.
So I think in terms of, I'm not going to tell you that the context doesn't matter at all. I mean, take the sensitive places law, right? They don't really affect the keep right the way that they affect the carry right, unless you try to say the entirety of Manhattan is a sensitive place, and then they might affect both. But in general, the analysis is going to be slightly different. But I would say that, I don't think those differences are material here. I think if the district, instead of just banning handguns inside the home, had adapted a permitting regime that required district residents to show that they had an atypical need to possess a handgun inside the home, I'm not sure anything in Heller would have been different, because it's just inconsistent with a constitutional right to either ban the exercise of it or say that it's a privilege that you can only exercise if you show that you are atypical from the rest of the people who are equally protected by the constitutional right.
Thank you.
Mr. Clement, are you able to hear me?
Loud and clear.
Right. Some of your amici have asked us to provide further guidance to lower courts in cases beyond your own. And so putting aside your case for the moment, they pointed out that some lower courts have refused to apply the history test, for example, and said they will not extend Heller outside the home until this court does. Other courts have applied intermediate scrutiny and variations of that. Some have suggested that strict scrutiny would be appropriate to treat this right comparably to other rights under our modern tiers of scrutiny. I'd just be curious what views you have about all that.
Thank you, Justice Gorsuch. I think we would start with the idea that text, history, and tradition is an appropriate way to deal with this right. That's what the court said in Heller. I think this court would allow the court to make clear that the same analysis applies outside of the home. And I think this case, like Heller, is such an outlier that the court wouldn't have to say too much more unless it wanted to. I think if it wanted to, though, it would already, I think, go a long way to correcting some of the mistakes in the lower court to say that text, history, and tradition is the test, not part of the test, but the test inside and outside the home. And if this court prefers to go the level of scrutiny route, I would simply say two things. One, we would prefer strict scrutiny as being consistent with a fundamental constitutional right. But even if it's going to be intermediate scrutiny, probably the single most important thing to remind the lower courts is that intermediate scrutiny requires narrow tailoring. And a law like this that takes a person who has no proclivity whatsoever, unlike the surety laws, to misuse firearms, and says you simply can't carry them for self-defense anywhere frequented by the public because you haven't demonstrated an atypical need, I mean, that's about as untailored a law as I can imagine. So I think if you did one of those two things, either make clear that it's text, history, and tradition outside the home as well as inside, or made clear that narrow tailoring is an integral component of the test, that would go a long way to clearing up some of the confusion in the lower courts.
So I kind of like this answer. I wish he'd been a little bit firmer on the strict scrutiny thing, because he kind of buried it a little bit by the end. Because when you talk about narrow tailoring, you're talking about, the intermediate scrutiny standard. But I do think it's appropriate in any case to remind them narrow tailoring. The Courts of Appeal do have a tendency to overlook that. They're like, well, it's narrowly tailored because it's a firearm restriction. It's like, no. And Paul Clement's better here. It's unlike the surety, which is a kind of bond. So people had to post a bond if they were particularly dangerous, if they wanted to carry firearms. So you can still carry a firearm as long as you put up a bond. Interesting idea. Unlike that, this is just a global rule, so it's not narrowly tailored. That's pretty good. Well, we do have a rule of respecting my mods, so, deal. Sorry. We don't talk about the modding. We don't talk about modding. Modding is not on topic.
I know you've had a substantial debate with your friends on the other side about the Statute of Northampton. We haven't heard about that today, and I just wanted to give you a chance.
Thank you, Justice Gorsuch. I'd say just a couple of quick things about the Statute of Northampton. First of all, I think that it was very clear from the Knights case and the treatises that this court relied on in Heller that by the time of the framing of the English Bill of Rights, that was not a general prohibition on carrying outside the home, but was a prohibition on either carrying unusual and dangerous weapons or using common weapons in a way that terrorized the public. And so I don't think that that supports the other side's position here. And the second thing I would say is that probably the single most obvious point about the history is there just are no reported cases on this side of the Atlantic, not in actual reporters, not in newspaper reports about crimes of the day, that show anybody being prosecuted for a violation of the Northampton crime simply by carrying common firearms for self-defense. And the one U.S. early court that dealt with this, the common law equivalent of the statute, was State against Huntley in North Carolina, which was an opinion that was cited favorably in the majority opinion in Heller. And that case went out of its way to say that simply carrying firearms per se is not an offense. It's the intent to terrorize the people that is prohibited by Northampton.
Thank you.
Justice Kavanaugh?
Mr. Clement, I have several questions. First, I want to make sure I understand your main problem here with this permitting regime, as I understand it, is the discretion that's involved with the permitting officials, and your point that that's just not how we do constitutional rights, where we allow basic blanket discretion to grant or deny something for all sorts of reasons. But I understand you would not object or do not object to the regimes that are used in many of the other 42 states, the shall issue regimes. I mean, there could be particular problems with those, but I do not understand you to object to shall issue regimes. Is that accurate?
That's accurate, Justice Kavanaugh. And as you say, there are especially if you have something like good moral character, there is the possibility for discretionary abuse in those regimes as well. But the thrust of this case is, we'd like what they're having. We'd like what the people in the other 43 states are allowed to do and exercise their rights. And in many of those states, it's shall issue. And that is, of course, New York purports to have effectively a shall issue regime with respect to hunting. The only other caveat I wanted to add is it's the discretion combined with the atypicality requirement. So if they came up with some, sort of like magic wand that gave them a precise reading of typicality, and so there was no discretion, but the standard was still at the end of the day you have to show that you are atypical from the rest of the people protected by the Second Amendment, we would have a problem with that as well.
Right. A shall issue regime with an atypicality requirement would be no good in your view.
Exactly. Even if it could be somehow, if you could come up with some objective standard of typicality.
Okay. And the issue before us, as I understand it, is the permitting regime. We don't have to answer all the sensitive places questions in this case. some of which will be challenging, no doubt. Is that accurate?
That's 100% accurate, and there's sort of a market test of the accuracy of that, which is New York does have sensitive place laws, and we have not challenged them in this litigation.
And then to follow up on Justice Thomas's question and also Justice Gorsuch's, we should focus on American law and the text of the Constitution, and we don't start the analysis in a vacuum, but we start it with the text, which you say grants a right to carry, and then historical practice can justify certain kinds of regulations, but the baseline is always the right established in the text. And there'll be tough questions as the arguments revealed about what the historical practice shows, but the default or baseline is the text.
That's absolutely right, Justice Kavanaugh, and of course that's no different from something like the First Amendment, where of course you start with the text, and it's very emphatic text, no law abridging speech, but then you look to history and tradition just to realize, oh, well, there's a long tradition of treating defamation and libel different going back to the framing, so you use that history to inform the text, but the focus is on the text.
And last question, following up on Justice Gorsuch's question, as he points out, some courts have used intermediate scrutiny or strict scrutiny. Those are balancing tests. I think Professor Alcia's amicus brief is very helpful on that. There's well-developed law in other areas. But it'll be no surprise to you. I have concern that would just be a balancing test that would make it a policy judgment, basically, for the courts. And I don't know why we would you say you'd be okay with that, but I'm not sure why we would smuggle all that into here, and then it would just be a policy judgment that would be unanchored from the historical practice.
So, Justice Kavanaugh, 2 points just in response to that. One, as you articulate the concerns with interesting balancing, that might be a reason that if you were going to go with the level of scrutiny's approach, you would go to strict scrutiny, where I just think there's less play in the joints. But the second...
maybe, but what's a compelling interest? Do you have a there's a lot of play in the joints in some of the other areas, so I don't know that you want to open that door.
And the second point I was going to make, though, Justice Kavanaugh, which is maybe more consonant with the thrust of the question, is, whatever was the case in Heller, where I sort of read the majority opinion as actually already rejecting interesting balancing, but whatever was the case in Heller, we now have this 13 years of experience with lower courts applying the test. And in our view, they've made a muddle of it, and it's probably the experience of the last 13 years is probably a very good reason to prefer a text, history, and tradition approach to this area of the law.
Thank you.
Justice Barrett?
Mr. Clement, I have one question. So a couple times, in response to my question about Times Square and New Year's Eve, and then just now as well to Justice Kavanaugh, you made reference to the First Amendment. And obviously, a lot of the questions that have been asked have been focused on how can the state fairly regulate? Because everybody agrees there have to be some regulations, and it might not be the case that we can always find exact historical analogs. So returning to the First Amendment. In response to me, you said, well, that might be analogous to a time, place, and manner restriction. So do you think the First Amendment and the, edifices that we have structured around it would be a helpful place to look? Is that what you're suggesting?
Well, I'm suggesting that there is a lot of useful teaching in the First Amendment. I'm not sure I'm suggesting you should just take sort of doctrines lock, stock, and barrel from the First Amendment. But, going back, well over 100 years to like Robertson, when the court was just talking in dictum about the First and the Second Amendment, it drew the analogy between allowing some restrictions on the Second Amendment and, in the First Amendment context, the First Amendment being consistent with libel and defamation. As I suggested to the Chief Justice, I think the way you think about a non-public forum and why that's different from First Amendment purposes from a park, I think could be useful in some of these contexts. If you focus on the nature of the location, you might say this is inappropriate for weapons, but in the same way as in the First Amendment, you just don't get to say, well, we're going to make it a non-public forum by saying no First Amendment activity there. You can't just take a location and say we're going to make this a sensitive place by saying no Second Amendment activity there. So those kind of analogies, and lastly, the analogy being you look at a law that says no concealed carry in a particular place on one night of the year quite differently from a law like this that says there's really no way for a typical New Yorker to conceal carry anywhere that the general public is allowed to go. Those under the First Amendment, those are radically different laws, and I think under the Second Amendment, those are radically different laws.
Thank you.
Thank you, counsel.
All right, let me pause here. I'll pause here to answer some questions and acknowledge some super chats. So first of all, let's do some super chats. We had a super chat from JTZKB. If you're arguing sensitive places, times, etc., you're conceding the general right because you're arguing exceptions. Very true as well. So that's also a very good point. Mithran Emmer says, once again, Breyer just shows he wants to take all guns away and do it with the Second Amendment. Absolutely true. Very true. JTZKB says, as a predator, it's good to know that she's not carrying openly. I can be confident she's not carrying. Fair. And 989 from Michael Sheridan. Been waiting for this one. Thank you for taking the time to walk us through. Are you the Michael Sheridan by any chance? But that'd be really cool. And also, let's take a look at the bots and be saying what questions you've had. Let's see. I'll answer at least some of these. Do I believe the Supreme Court will make a profound decision? I'll put myself full screen while we're doing this. Why not? Because that way you get to see more of me. Do you think the Supreme Court will make a profound decision on Second Amendment, or will they once again make a very limited determination? I would expect them to, my bet is they're going to say something like there's a right to bear arms outside the home. It has to be either open or concealed. Dealer's choice from the states on which one they want, and hopefully they will tighten up the scrutiny issues, as was just alluded to, because the way the courts have been doing it has not been helpful. So I'm not sure if this text, history, tradition thing is the right way to go, or if strict scrutiny is the right way to go. But either way, they hopefully will tighten that up. So that's what I'd be hoping for. But I would bet they're going to say there's a right to bear arms generally outside the home in non-sensitive places, and that cannot be based on a specialized need, and then go beyond that to some other stuff. But that's what I'd be expecting. Not much more than that. Patrick Tracy says, there are a lot of amici. There sure was. Do you think they'll address some of it? Some of it maybe, but probably not for the most part. I'd actually expect to see that more in the dissent than the majority opinion. Internet commentator said, could Congress establish a generalized privacy right? Through amendment, yes, they could do the through amendment for sure, because amendments are, a big hammer and can basically do anything. Through a statute, maybe, but they would run into some issues with the constitutional mechanisms to make that happen. What would be their constitutional hook? So I'm not so sure about that, to be quite honest. Internet commentator says, okay, random trivia question. What do you think is the most wrongest legal interpretation theory case that's good law? You know the answer to that, man. Take your pick between Wickard and Chevron. JS says, why do you think the liberal Supreme Court justices think it's their job to soapbox or take political stances? Crack says, I've heard some argue that the two ways the citizen's right to permit carry. What's your opinion of that argument? Well, the question is, when we talk about the right, I always love these people who say shall not be infringed, and then I'm back to what shall not be infringed. Keeping and bearing arms. No, that's not what the Second Amendment says. It doesn't say keep and bearing arms. It says the right. And then we have to talk about what the right is. So I don't think you can go that far. You have to go a little. It's a much more nuanced question with a historical analysis. In the same way, the First Amendment is a more nuanced question. It's very, very similar in that respect. If the Fifth and 14th Amendments hold water, isn't the Ninth Amendment substantive due process argument for arguing inalienable rights under the Second? The Ninth Amendment's not really a good argument for anything. Internet commentator says, can you explain to Bob Hope the importance of strict scrutiny and why all rights have limits? Well, I don't know if it's correct to say that all rights have limits so much as all rights have boundaries, which may be the same thing depending on your point of view. But yeah, all rights have boundaries, because when you talk about the freedom of speech, for example, okay, what is the freedom of speech? It has boundaries. And some of those we well know because the First Amendment is more well developed. But we know, for example, it doesn't include things like defamation. It doesn't include things like fighting words. It doesn't include things like true threats. right? So this is, again, going back to the word "the," which I think is the single most poorly understood word in the Second Amendment, and the one that's most significant, because you talk about the right to keep and bear arms. What is the right to keep and bear arms? And as someone was trying to analogize it before the stream started, it's a little bit like the difference between talking about a cookie and the cookie. You have a right to a cookie. That could be a lot of different things, because there's a lot of different kinds of cookies, right? So if I say you have a right to a cookie, then you're like, great, I want this kind of cookie, I want that kind of cookie, I want this kind of shape, I want that kind of shape, blah, 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 right? If you have a right to a cookie, then that's a lot of different latitude. If I say you have the right to the cookie, then we're talking about a specific cookie, so you're constrained. It's like, well, I want chocolate chip. Too bad, my friend, because this particular cookie is oatmeal raisin, and that's what you have the right to. But I have the right shall not be infringed. Right, you have a right that shall not be infringed as to the oatmeal cookie. You don't have the right to the chocolate chip. But I want chocolate chip. Too bad, that's not the cookie. I wish it was bigger. Too bad, it's this. Too bad, it's this size. I wish it had this shape. Well, too bad it has this shape. Right, so it has its own boundaries that are defined by the object. It's like, yeah, I have a right to the thing. And what is the thing? And what are the boundaries of the thing? So yeah, what shall not be infringed? The thing shall not be infringed. Okay, well, we still have to figure out what the boundaries are. It's a little bit like a piece of land, right? You shall not trespass on the property. Great, what is the property? Now we have to start getting out surveyors, right, and start talking about boundary lines. So it's very similar in that way. As for strict scrutiny, why it's so important, because if you talk about strict scrutiny, in order to have a regulation or a law that's valid, then you have to have a compelling governmental interest, and it has to be narrowly tailored to that interest. So you have to make sure, basically like the least restrictive means. Could you do anything less? So strict scrutiny has been called strict in theory and fatal in fact, because it's very, very difficult indeed to find things that pass strict scrutiny. It happens, it does happen, but it's, basically borderline impossible, because it's supposed to be borderline impossible. It's strict. So that's why it's important. Hopefully that answers some of your questions, and questions you didn't ask for that matter. Bob says, so under strict scrutiny doctrine, would the regulations imposed by states impede upon and prejudice or discriminate against citizenry in this particular matter? I don't know. When you ask me a question like the regulations imposed by states, that's a lot of different things, Bob. I would assume that some of them would pass muster and some of them would not. They all have to be analyzed individually, as you do. They all have to be considered separately onto their own merits. Is there any chance of nationwide constitutional carry out of this? No, there's no chance of that happening. Could I go over U.S. versus Miller? I think I've done it before, but Stella says, why doesn't the right to keep and bear arms shall not be infringed mean there's no need for a permit? I think I kind of discussed that. You forgot the most important word in the sentence. You thought the most important word in the sentence was not, because that's the one you put in all caps. The most important word in the sentence isn't not. The most important word in the sentence is the. And now we have to start talking about the, and historical analogies, and going through an entire history analysis. Marcus says, I like you and your content, but I'm not going to support censorship. Well, that's too bad, Marcus, because it's my channel, it's my house, my rules. It's my house, and I get to determine what the conditions are for playing in my house. Have your own channel with your own rules if you'd like. Elidian says, isn't that Clement being cautious about overreach? Maybe strict scrutiny would be a huge change. Maybe there's something there. Did they say anything about the New York State pistol permitting law requiring permit as a prerequisite to owning? That's a different kind of permit and not the issue here. So it's not going to be brought up because it's not the issue here. It's a different kind of permit. How long do you think before we get an opinion? Don't know. Peter says, would a better way for him to word this would be there's no way to carry, rather there's no way to conceal carry? Possibly, yes. Maul says you need to have a call, and some people want to have a conversation. I think that'd be too unwieldy, but maybe we'll look into it in the future. And Philip says, what is your favorite kind of cookie? As it happens, my favorite kind of cookie is a white chocolate macadamia. So it was none of the cookies that I mentioned. But now you know. I like the white chocolate macadamia. I think they're OP on the cookie tier. Let's go back and listen to some more oral argument, shall we?
General Underwood.
Mr. Chief Justice, and may it please the Court, for centuries, English and American law have imposed limits on carrying firearms in public in the interest of public safety. The history runs from the 14th century Statute of Northampton, which prohibited carrying arms in fairs and markets and other public gathering places, to similar laws adopted by half of the American colonies and states in the founding period, to later state laws that relaxed restrictions for people who had a concrete need for armed self-defense. Starting as early as the early 1800s, states began taking different approaches to regulating firearm carrying in public. Some states provided that a person who carried firearms in public without reasonable cause could be arrested and required to post a bond. Other states made it a misdemeanor to carry a handgun without reasonable grounds to fear an attack. Other states and territories banned carrying handguns in towns and cities altogether, or restricted it to situations of immediate threat. And in the early 1900s, many states made good cause a requirement for a license to carry a concealed handgun, while also prohibiting, in some cases, the open carrying of handguns. In total, from the founding era through the 20th century, at least 20 states have, at one time or another, either prohibited all carrying of handguns in populous areas or limited it to those with good cause. New York's law fits well within that tradition of regulating public carry. It makes a carry license available to any person, not disqualified, who has a non-speculative reason to carry a handgun for self-defense. New York is not an outlier in the extent to which the state restricts the ability to carry firearms in public, and it's not an outlier in asking a license applicant to show good cause for a carry license. Many ordinary people have received carry licenses in New York State. If the Court has questions about how the law works in practice, it should remand for fact-finding. And if the Court finds the history ambiguous, it should review the law under intermediate scrutiny and uphold it.
General Underwood, you seem to rely a bit on the density of the population. You say, I think, that states like New York have high-density areas. And the implicit in that is that the more rural an area is, the more unnecessary a strict rule is. So when you suggest that, how rural does the area have to be before your restrictions shouldn't apply?
Well, I think the way the New York statute works is consistent with a reasonable rule, which is that there's not a cutoff, there's not a number at which things change, but that licenses, unrestricted licenses, are much more readily available in less densely populated upstate counties than they are in dense metropolitan areas. And that is a virtue of the system of having licenses handled by licensing officers who are part of the local community and who take the density of population into account, as well as the many other factors.
Well, Mr. Nash lives in quite a low-density area. That's why I'm interested in where your cutoff is. It's one thing to talk about Manhattan or NYU's campus. It's another to talk about rural upstate New York.
He actually lives in what I would call an intermediate area. He lives in Rensselaer County, which is not that far from Albany, and it contains the city of Troy and a university and a downtown shopping district, but it also contains substantial rural areas. And that is precisely what the licensing officer here was taking into account when he made the differentiation between, don't take it to the shopping mall, don't take it downtown, but you can take it in the sort of backcountry areas.
Thank you.
General, you mentioned that the gun is, I guess permits are more readily available in a less populated area.
Unrestricted permits.
Unrestricted permits
are more readily available in less populated areas, yes.
Now, Heller relied on the right to defense as a basis for its reading of the Second Amendment, or that was its reading. Now, I would think that arises in more populated areas. If you're out in the woods, it's pretty unlikely that you're going to run into someone who's going to rob you on the street. On the other hand, there are places in a densely populated city where it's more likely that that's where you're going to need a gun for self-defense. And, however many policemen are assigned, there are high crime areas. And it seems to me that what you're saying is that's probably the last place that someone's going to get a permit to carry a gun. How is that, regardless of what we think of the policy of that, how is that consistent with Heller's reasoning that the reason the Second Amendment applies a direct personal right is for self-defense?
Well, I'll say a couple of things about that. One, if you go right to history and tradition, the history was to regulate most strenuously in densely populated places. That's what fairs and markets are. So we have history. But we also have a rationale for that history, which is that where there is dense population, there is also the deterrent of lots of people, and there is the availability of law enforcement. In England, the idea was that it was the king's peace, and it was in fact an insult to the king for people to take things into their own hands.
Well, but that's not always true. It depends, obviously, in the jurisdiction and all that, but simply because a place is, well, it's paradoxical that you say a place is a high crime area, but don't worry about it because there are a lot of police around.
Well, and the other thing is that these regulations are all an effort to accommodate the right to recognize and respect.
I love how she didn't answer the question. She didn't answer the question. She just completely ignored it, or the implied question. It's paradoxical to say a place is high crime, but it's okay because there's lots of police. And she has no response, so she just completely moves on. That's entertaining.
The right of self-defense while regulating it to protect the public safety. And in areas where people are packed densely together, as the questioning that just happened displays, the risks of harm from people who are packed shoulder to shoulder, all having guns, are much more acute than they are.
Oh, sure. And I can understand, for example, a regulation that says you can't carry a gun into, giant stadium, just because a lot of things are going on there and it may not be safe to have for people to have guns. On the other hand, if the purpose of the Second Amendment is to allow people to protect themselves, that's implicated when you're in a high crime area. It's not implicated when you're out in the woods.
Well, I think it is implicated when you're out in the woods. It's just a different set of problems. I mean, you're deserted there, and and law enforcement is not available to come to your aid if something does happen. But
well, how many muggings take place in the forest?
If we
how many do you think?
I don't know, but I will tell you that our licensing officer told us that rapes and robberies happen on the deserted bike paths, and that he has some concern about that. So, I mean, I take your point that there is a different risk in the city, but there is also a different public safety consideration. And that is why the licensing officer is meant to take into account not just the risk, but also the population and the availability of law enforcement and all these considerations. I won't say that the risk — I think it's not correct to characterize the risk as atypical. The risk has to be specific to the person. What the cases say is that you can't just say, I'm afraid, because based on facts that are not specific to you. But what Mr. Nash did was convince the licensing officer that his trip to a deserted parking lot every night was sufficient.
What if it's one of these crime ways, whether it's a celebrated spate of murders carried out by a particular person, I don't know who that is, the son of Sam or somebody else. Is that a good reason to is that a atypical reason? Is that a justification? Some random person is going around shooting people. I'd like to have a firearm even though I didn't feel the need for one before?
Well, I think that it would have to be brought home to you in particular, to your route, to your parking lot, to your your apartment building, but something specific to you rather than it's happening in the world at large. That's what's meant by something non-speculative.
Barbara Underwood over here does not want you to be able to get a concealed firearm if the son of Sam is trying to kill people. So, okay, that's a position, I guess.
Could I explore what that means for ordinary law-abiding citizens who feel they need to carry a firearm for self-defense? So I want you to think about people like this, people who work late at night in Manhattan. It might be somebody who cleans offices, might be a doorman at an apartment, might be a nurse or an orderly, might be somebody who washes dishes. None of these people has a criminal record. They're all law-abiding citizens. They get off work around midnight, maybe even after midnight. They have to commute home by subway, maybe by bus. When they arrive at the subway station or the bus stop, they have to walk some distance through a high-crime area, and they apply for a license, and they say, look, nobody has said, I am going to mug you next Thursday. However, there have been a lot of muggings in this area, and I am scared to death. They do not get licenses. Is that right?
That is, in general, right, yes. If there's nothing particular to them, that's right.
How is that consistent with the core right to self-defense, which is protected by the Second Amendment?
Because the core right to self-defense doesn't, as this Court said, doesn't allow for all to be armed for all possible confrontations in all places.
No, it doesn't. But it doesn't mean that there is the right to self-defense for celebrities and state judges and retired police officers, but pretty much not for the kind of ordinary people who have a real felt need to carry a gun to protect themselves.
Well, if that ordinary Mr. Nash had a concern about his parking lot and he got a permit, I think the extra problem in Manhattan is that your hypothetical quite appropriately entailed the subways, entailed public transit, and there are lots of people on the subways even at midnight, as I can say from personal experience, and the particular specter of a lot of armed people in an enclosed space.
There are a lot of armed people on the streets of New York and in the subways late at night right now, aren't there?
I don't know that there are a lot of armed people.
No?
There are people with illegal guns, if
that's what I'm
referring.
talking about.
Yeah.
How many illegal guns were seized by the New York Police Department last year? Do you have any idea?
I don't have that number, but I'm sure it's a substantial number.
But the people, all these people with illegal guns, they're on the subway. They're walking around the streets. But the ordinary, hardworking, law-abiding people I mentioned, no, they can't be armed.
Crush it, Alito. Just crush it, How about the janitor? How about the nurse? How about the worker who's getting off in their shift at midnight or after midnight? And because they're working at a low class job, and Manhattan is uber expensive. That means they don't live in Manhattan, so they probably don't have a car. So that means we're back to public transport, buses and stuff. And it's like, how about them? It's like, well, they can't get a permit. What? How many people are there with guns on the subways? Not that many. Really? How about all the illegal guns? Oh, that's right. So But so the celebrity can get it, the retired judge can get it, the ex-police officer can get it, the criminals can get it, but not this hard-working person. Get it, Alito. Get it. Yeah.
Well, I think the subways when there are problems on the subways, are protected by the transit police is what happens, because the idea of proliferating our...
Oh, okay. Okay. Oh, that's a great answer. That's a great answer, Barbara Underwood. When there are problems on the subway, they're protected by the transit police. They're protected by the transit police. Well, I feel better. My concerns have been satiated. The transit police are there to help me on the subway. That's great.
On the subway is precisely, I think, what terrifies a great many people. The other point is that proliferating guns in a populated area where there is law enforcement jeopardizes law enforcement, because when they come, they now can't tell who's shooting, and the shooting proliferates and accelerates, and in the end, that's why there's a substantial law enforcement interest in not having widespread carrying of guns.
On the standard of particular to them, just to follow up on the other questions, why isn't it good enough to say I live in a violent area and I want to be able to defend myself?
Well, what happens in these license hearings is that a question is asked, what exactly do you mean? Because
the statistics.
It depends on how large an area you describe. You could say I live in a violent area, and that could be all of New York City, or it could be your particular neighborhood. And the closer it gets to your particular neighborhood, the better your claim is, or your block. Now, I know that one of the petitioners made an assertion about robberies on his block. I also know that there was a hearing about that, and he evidently did not convince the licensing officer that they were sufficiently recent or relevant or couldn't be dealt with adequately by his own premises license, which he would be entitled to have without any justification or proper cause at all. So what I know happens is that those claims are examined by a licensing officer. Now, this gets to to questions about discretion and whether that's effectively handled, but
well, that's the real concern, isn't it, with any constitutional right? If it's the discretion of an individual officer, that seems inconsistent with an objective constitutional right. I mean, what if you're a runner? You say, I run a lot. And as you correctly pointed out earlier, there are a lot of serious violent crimes on running paths. It's a real problem. Is that good enough?
Probably. I mean, that's the counterpart to Nash's claim. But
probably,
if that's the question, that is not the way this case was tried. That's not the way this claim was framed. And if the question is, does the system actually operate in the way that we're describing, then this case should be remanded for a hearing to determine whether it does.
So she says that anyone who runs on running paths can get a concealed carry firearm in New York? Tell you what, man, I've never had a better motivation to take up running in my life.
And what's the problem with the shall issue regimes from your perspective that exist in many other states, including very populous states, Florida, Illinois?
The problem with the shall issue regimes is that they multiply the number of firearms that are being carried in very densely populated places, and there is a much higher risk, without assuming any ill intent on the part of the carriers of weapons. They greatly proliferate the likelihood that mistakes will be made, fights will break out.
But has that happened in those states? I mean, can you make a comparative judgment? Because it seems like before you impose more restrictions on individual citizens and infringe their constitutional rights based on this theory, you should have to show, well, in those other states that have shall issue regimes, actually there is a lot more accidents, crime, and I don't see any real evidence.
Tim Green says the Supreme Court should be elected. I mean, with all possible respect, Tim, I think electing judges is actually a really bad plan. I think people are not particularly great at picking judges. Them being appointed has their own set of problems, to be sure, but yeah, I don't think electing judges is probably the right answer for the most part. For state judges, states can play and experiment with that. For federal judges, of course, this means I'll never be a federal judge, which is annoying, but that's okay.
of that.
Yeah, I think there is a brief from the social scientists that addresses this, but this law has been in place since for over 100 years, starting at a time when the law.
She has no answer. She has no answer for this. Kavanaugh asks her about how has it worked in other states, right? So she says, the problem with shall issue is that there's a lot of guns and it will proliferate likelihoods of mistakes. And then Kavanaugh says, but reality, though, that hasn't happened. It doesn't see any evidence. And her only response is, but this law's been in place for 100 years, though, which isn't an answer to the question. Right? She says, okay, concealed carry is dangerous because it will proliferate people having guns in high-density areas. Okay. Let's talk about Miami. Let's talk about Houston. Let's talk about Dallas. Let's talk about, Phoenix. Let's talk about insert many other cities of your choice in this sentence. Has it been a nightmare where the people with the concealed carries are causing massive problems everywhere? What are you talking about? She has no answer except this has been a law for 100 years. Kavanaugh's killing it. Alito's killing it.
Law was not as well understood in this area as it is now, and so it's a little bit anachronistic to talk about before you put this law in place you should have evidence. But I believe there is evidence about the success that New York has had in keeping in keeping gun violence down that is attributable to the reduced number of guns that are being carried, particularly in these densely populated places. So,
General, one of the things that strikes me about this area is that on the one hand, it seems completely intuitive to me, and I think to many people. If you think about Justice Thomas's questions about less populated areas, the rural areas of New York versus the cities, it seems completely intuitive that there should be different gun regimes in New York than in Wyoming, or that there should be different gun regimes in New York City than in rural counties upstate.
Now, it might be intuitive. I'm not disputing that it's intuitive, but intuition isn't always right. And again, we could point to the reality. Okay, the intuition is the implied intuition is if we have guns in big cities, it will be a problem. Okay, because there'll be a lot of people with guns in a relative, area. So that's intuitive, but how about the reality? We have, since 1986, I believe, was when Florida passed its concealed carry firearm law, and the rest of the states finished. So we have 40 years, give or take, of experience. And so, experience has belied intuition. But she's still relying on intuition rather than experience.
But it's a hard thing to...
And regime is not a clue. It's just a legal word. I wouldn't read too much in her using the word regime, different gun regimes. I wouldn't read too much into that word, personally.
To match with our notion of constitutional rights generally. Mr. Clement makes a big point of this in his brief about how we would never really dream of doing that for the First Amendment or other constitutional rights. Allow that level of local flexibility that you are basically saying we should allow in this context. So I guess I just want to hear you say why you think that is. What justification is there for allowing greater flexibility here?
Well, I think one point is that there is a very wide range of sort of distribution of rural and urban and different kinds of areas, not just across the whole state, but within counties. And so delegating the decision-making with appropriate criteria to somebody who is local, which is what this is. These are local judges. In most of the state, they're judges. To make the relevant fact findings, to make the relevant inquiry. This is an interactive process in which these individuals and others are told I'm not going to lift the restrictions now, but if you come back, if you have more to say about this, feel free to come back. It's an ongoing process. It's one reason why there isn't so much appellate litigation, is that that is what happens. So it's hard to see how you could specify everything in advance and have it be a clear on-off switch and still take adequate account of, on the one hand, the need for self-defense, and on the other hand, the strong public safety concerns. And that's why I think this system...
I don't think that was Justice Kagan's question.
Oh, I'm sorry.
It was on a broader level, I believe. She can correct me if I'm wrong. The issue is, no other constitutional right do we condition on permitting different jurisdictions to pass different regulations. But do we have any other constitutional right whose exercise in history has been as varied as gun possession?
All right, let's give her a second bite at the apple. 2 for 2. So she's been asked the same question a second time. Let's see if she gets it right the second time. Are there other constitutional rights that are or should be regulated differently based on, for example, population density? Let's give it another go, Barbara. Can you get the answer? Can you answer the question on number 2?
Well, I think that's right, both at the local level, and at the state-to-state level. We have a strong history here of a range of responses from state to state that is based on local conditions and local concerns. And what we have within New York is an effort to recognize we have almost the same range of different kinds of spaces within the state, and this is the effort to accommodate that. And if the history warrants taking local conditions and local population density and so forth into account, it's hard to think of another way to effectively do that. There is, after all, appellate review available here, all the way to the central, to the highest state court.
Swing and a miss. Swing and a miss. 0 for 2. We didn't answer the question. 0 for 2, we didn't answer the question. Hey, it seems intuitive that we should regulate differently in cities versus in the country. It seems intuitive we should have different regulations in Montana and Wyoming than, for example, New York City. Now, first of all, I'd say it's belied by experience, but let's accept the premise because it doesn't matter either way. So we'll accept the premise. Great. All right, so where else is this true for other constitutional rights? What other constitutional rights do we say, okay, this is a rule in Montana and Wyoming, but not the rule in New York City? What other constitutional rights do we start looking at these population-based concerns? And her second answer is particularly incoherent. I think that's right, both at local and state level. We have strong history of responses, different kinds of space within the state, and history warrants taking local conditions into account. And there's appellate review. Just total swing and a miss. 0 for 2. And I don't know what it means in terms of a decision in terms of Kagan or Sotomayor, but Kagan and Sotomayor tried to give her, hey, please tell us a reason. Please tell us a reason we can do this. And she can't even answer the question. She's not on point. She's nowhere near the question. Probably because there's not really a great answer. Now, she could try to say, well, there's no other answer, but now what a answer could be, in case you're wondering what an answer could look like, right? What you say in law is it's sui generis, right? So it's basically a self-generating. So you say, okay, this has never happened before, but it should happen here, right? Now, that's not necessarily a great answer, because you're trying to create a completely new exception for just this right, and this right being special. But, guns bad, so you can get that going for you, right? So it's like, okay, we don't do it in any other area of constitutional rights. But we should do it here because of the particular nature that guns have and the particular nature of them being in high numbers, in high density places, warrants a different result in this context than it would in other constitutional rights. So that's an honest answer. It's an honest answer. It's an on-point answer. It's saying, okay, this is sui generis. It's self-generating. Of course, she doesn't do that, and she doesn't come up with any other version of it. She's just like, we have history of regulations on the state level and appeals. Okay, that's great.
Thank you, counsel. Justice Thomas, anything further?
But let's just take, for example, hunting. That's something I think we can agree on. You can't hunt I'm sure, with a gun in Central Park. But I'm certain that there are places in upstate New York or even in western New York where you can. I don't
Including Rensselaer County, yes.
Yeah. So I think what we're asking is if that you can have that difference for the purpose of hunting specifically, why can't you have a similar tailored approach for Second Amendment based upon?
Ooh, wow, strange question coming from Clarence Thomas, isn't it? It's like, this is a very strange question coming from Clarence Thomas. Clarence Thomas is saying, okay, we do this in hunting regimes. We allow hunting in remote places, not in the city. Okay, great. But so can we do that when it comes to this for the Second Amendment? Now, the right answer to this question, not from her, because she's not going to give this answer, but the right answer is because hunting isn't a right. But the Second Amendment and right to defend yourself is, sees, for example, Heller and McDonald for that proposition. But why is Clarence Thomas like feeding her the answer? Clarence Thomas is feeding her the answer. So that's an item of concern.
If it's density in New York City, if that's a problem, the subway, then you have a different set of concerns in upstate New York.
Well, hunting permits work for particular locations, for particular areas, but it's all one statewide regime. I mean, and so too here, licenses are handled locally. It's not exactly the same, but it's the same model that licensing of handguns to carry a handgun for self-defense is handled locally under a single set of criteria, but with reference to local conditions. I think that's right.
Okay, this woman might need help. Okay, this woman might need help. Clarence Thomas, for reasons that pass our collective understanding, gave her the answer, and she was unable to then give him back the same answer. So he just gave her an answer, and it's not necessarily the answer, because there might be other answers. There might be other answers, like I gave, for example, an answer, right? I gave an answer, like sui generis. It's a self-generating thing. This is particularly dangerous because of the obvious threat of death and death that curtails. So, we need to treat this as a unique. This regulation flows from the particular needs of the Second Amendment. So I gave an answer, sui generis. All right, so that was an answer. Clarence Thomas comes up with a different answer. All right, how about this? We regulate it when it comes to hunting, and we allow it in the rural places and not so much with the density. So why can't we do that here? So he feeds her a different answer. And then she's completely unable to repeat back the answer. What she should have said is something like, "That's completely correct, Justice Thomas. In the same way that we regulate hunting when it comes to density because of the nature of firearms and other weapons used in hunting, and we don't allow them in dense populations because of the danger to the public. In the same way, too, we should here regulate when it comes to concealed carry permits because of the unique dangers that firearms and other weapons pose in high density environments." Something like that. Something like that. Just repeat the same thing he said to you in other words. And she can't do it. She can't do it. He gave you the answer, and you couldn't do it. Oh, Lord. Let's read some more.
Are we considering here just the upper state New York law? We're not considering New York City, are we?
I don't see any reason to be considering New York City.
Okay, so it's not in the case.
Petitioners are not from.
They're not.
See,
okay,
yeah.
all right. Now, if you're trying to get uniformity, doesn't the First Amendment, isn't it filled with local statutes use the word may, parade permits, event permits? So
yes.
It's not special. Can you
Correct.
think about
in the areas where permitting happens, which includes First Amendment areas, it could be parades, it could be solicitation for charity. There are various areas where First Amendment activity is
so what I'm driving towards, and I thought also there is a brief here, I think it's the social scientists, remember the name of it, which says in instances where, and they do it statistically, they are more liberal in allowing people to carry concealed weapons who are good character people, and there is a greater risk of a crime or harm, where that happens, there are more deaths of innocent people. What is that brief? I'd like to go back and look at the figures.
All right, so Justice Breyer tries answer number 3. Answer number 3 is not quite as good as the previous two because she can echo back the answer, which why not? It's just that there's a counter that's obvious because there aren't really different regulations when it comes to the First Amendment. They just kind of apply differently as a matter of practice because of the density issues. So it's not quite right as the analogy, but you know, you don't have to make that point, right? That's the point the opposite side would be making. So Breyer gives you idea number 3. Okay, how about the First Amendment? We have permitting in that area. Now here she's able to give him back the answer, but she does it poorly. She's still scattering all over the place. What she should have said again would be something like, "That's a very good observation, Justice Breyer. We do regulate the First Amendment when it comes to permitting. And we do, as a matter of course, treat permitting differently in rural areas than in city areas because of issues relating to population. So in the same way, it would be perfectly valid to have permitting regulations treated differently and evaluated differently in high-density places rather than low-density places." Something like that. She got closer this time, though, but she still didn't get there.
Yeah, I believe it is a brief of social scientists, but
all right, I'll find it.
Yeah.
But do you think it's useful to, were we to have a trial, could we go into that? I mean, I think the great problem would be, fine, let's have some absolute rules, uniform national rules. I'm not sure we have those in the First Amendment, but assume we do. What are they? What are those rules?
You're not sure we have uniform rules in the First Amendment? I mean, I can think of some. Decided by your court. Okay.
Well, I think they would end up being factors that have to be taken into account because the range of situations is so different, both on the need side, on the public safety side. So I think it's very hard. In fact, that's one of the things that I think is hard about the suggestion that a sensitive place regime could replace a system like this.
Or if you had a guess on how many concealed carry licenses are given in the area under consideration, upstate New York or outside of New York City, in a given year or around, any way you want to put it, are they in the tens of thousands? Are
well,
they in
I can't do it statewide. I have statewide estimates, not estimates. I have permits for Rensselaer County and for statewide. It would be possible to get more, but I don't.
Are they rough? What are they?
This is in footnote 10 of our brief. In the 2-year period, 2018 to 2019, in the state, there were approximately 37,800 grants.
I get the rough idea. And if, in fact, it were remanded, I guess we could go into that in more depth.
That's correct. That's correct. We have the grants. Of course, there are licenses that weren't granted in those years that are still valid, so that doesn't tell you how many the thing we had to estimate was the grant rate because we don't have application data. We had to estimate that from other information, but we have the permits.
Justice Alito?
Is it correct that the non-speculative...
She's not very sure of herself. We've heard lots of great women advocates on the U.S. Supreme Court, but she's not very sure of herself. She feels unpracticed. I don't know if that's true or not, but she's not great. We've heard lots of female advocates that are wonderful at the Supreme Court. Some are truly awesome, but she seems very unsure of herself, very unsure of the information. I would think you'd have information like number of concealed carry permits in statewide and in the county and maybe New York City off the top of your head, because those, would be the ones that you would most want to know. But I don't know, seems a little weird.
The standard applies throughout the state. It applies equally in New York City and in the most rural location in upstate New York.
Well, it has been...
Falcon Eye, if you want to have this without commentary, I would suggest that, humbly, you can go to oyez.org, and they have the entire oral argument for you, and you can skip to any part of the oral argument you like and listen to it without commentary. If you want, you're coming to my channel presumably for some legal commentary and thoughts. So, that's what we're doing here.
The law has been interpreted to mean that, although the experience of granting licenses, or the experience with license applications, is that it is apparently more readily satisfied upstate.
So the individual officers have a degree of discretion.
Well, yes, they're asked, like judges on many issues, they are asked to take into account certain factors. They can be reversed if they took the wrong factors into account or if they failed to take the specified factors into account. It's not unguided discretion, but it is discretion in the sense that...
What guarantees, if any, are there in your regime that a licensing officer is not taking into account improper factors?
I mean, this is a question about the judicial system generally. If he correctly records the factors that he took into account, they write letters or opinions which may or may not fully disclose. One assumes will disclose what they thought was important. When often they're not just the papers, but there are if he denies the license, he will say why. He has to say why.
We've been presented in your brief and all the other briefs in this case with an enormous amount of history, citations to all sorts of statutes and other sources. Would you be willing to concede that maybe you got a little bit overly enthusiastic in your summary of some of the historical sources that you cited in your brief? I'm going to give
we did our best to be accurate in reporting what we reported. I don't know what you have in mind.
Yeah, well, I'm going to give you an example, which is, it's troubling. I can see how it would slip through. I'm not accusing you personally of anything. But on page 23, you say that in founding era...
Now, this is a nice little point here from Justice Alito. So I want you to really note here what's happening. Okay, so because I knew this part was coming because I read about it in an article. All right, so Justice Alito is saying, you're basically misrepresenting the law. We're about to say, right? So he says you're about to quote something. You're about to quote something as a legal proposition, and you left off a critical word from what you cited. And he seems to be implying this is not the only time she's done it. So he's accusing her of being dishonest in her representations to the court, which is a big problem. Lawyers have to be honest before the courts. If they have bad authority, they have to be honest about the bad authority. You can argue against bad authority. It's fine. If you have bad authority, it's like, well, let's change it. I mean, you are at the U.S. Supreme Court. They're the ones who can help you fix that problem. So it's like, yeah, we have bad authority. So, you can fix that. But he's about to accuse her of, misquoting the law and being dishonest. So just pay attention to, and then she doubles down on it, which is even worse. So just pay attention to this little exchange here. So I'll go up a little bit more and just so you can hear the whole exchange.
I don't know what you have in mind.
Yeah, well, I'm going to give you an example, which is, it's troubling. I can see how it would slip through. I'm not accusing you personally of anything. But on page 23, you say that in founding-era America, legal reference guides advise local officials to, quote, arrest all such persons as in your sight shall ride or go armed. And this is a citation to John Haywood, a manual of the laws of North Carolina, 1814. So I looked at this manual, and what it actually says is, you shall arrest all such persons as in your sight shall ride or go armed offensively. And somehow that word offensively got dropped from your brief.
I
would think that's an irrelevant word?
I think it would have been better to put it in and make an explanation, but I do think it's an irrelevant word because we have substantial authority for the proposition that guns were deemed to be offensive weapons. And that's why we have this dispute about whether saying, there are different ways of putting it, offensively or with offensive weapons or to the terror of the people. These either describe a separate characterization, a separate feature that not all weapons have. That's my friend's position on this. Or they describe the belief that all such weapons are offensive.
Well, I don't want to belabor the point, but of course if any possession of weapons outside the home was illegal, then there would be no need to put in the term offensively, the inclusion of that.
Well, there are many other weapons. Usually there's a list that's it's not in this particular instruction, but there will be a list of weapons. They were talking about much more than guns, and it was guns that were said over and over again to be offensive.
All right, well, thank you.
Now let's take a look at this this part of the manual according to him, so we can see what this says. Okay, so he actually goes and looks up the original material. Good for him. So she says, arrest all such persons as in your sight shall ride or go armed. But it actually says, you shall arrest all such persons as in your sight shall ride or go armed offensively, which implies that's possible to go armed in a non-offensive way. That's his point, right? Why would you say offensively? Because there must be an alternative. There must be an alternative, which would be unoffensively or non-offensively. So you only arrest those who are riding or going or traveling, only those who are doing so armed offensively. And so she just basically doubles and triples down. It's like, well, all guns were offensive. But no, that's not really what it says. It implies that it's possible to go armed unoffensively. So she's misrepresenting the law, and Alito's calling her out big time. I don't know if that will sway any of the left justices, but that's the kind of thing you don't want to get called out on at a Supreme Court argument. I think we can all accept that as true.
Thank you.
But that's the explanation.
Justice Sotomayor? Justice Kagan?
You started a thought and then you were taken off someplace else, so I just wanted to allow you to finish the thought. What you said was that there was a reason why a sensitive place regime cannot serve as a replacement, and then you were not given an opportunity to say why. So why?
Well, essentially because there are it would be very hard in the first instance, and I think also not very acceptable in to my adversaries in the second instance, to specify in advance all the places that ought properly to be understood as sensitive. So it sounds like a very convenient alternative. But, for example, we were talking about Times Square on New Year's Eve. Times Square when the theater district, when commerce is in full swing, Times Square almost every night is shoulder-to-shoulder people. So then you end up having a very big difficulty in specifying what all the places are that have the characteristics that should make them
sensitive. It has, in principle, it has an attractive quality to it, but in implementation, I think it would be unsuccessful.
Justice Gorsuch?
No further questions. Thank you.
Justice Kavanaugh?
No, thank you.
Justice Barrett?
I have one. General Underwood, do you think Heller was rightly decided?
I think there is a lot of support historically and otherwise for it, so I'm quite content to treat it as rightly decided. I think
Interesting response from her. I wouldn't have expected that response. That was rightly decided. I would have expected her to say, it's the precedent of the court, and I'm happy for it to be the precedent of the court, but, I disagree with it for the reasons said by the dissent. But I understand it's the law. But for her to say it's correctly decided, I think undermines her position. It's interesting that she says it's correctly decided. I'm trying to understand this from a tactical point of view because this question was anticipatable. So I'm assuming that this is not an answer she's thinking up off the top of her head. So I'm trying to consider the tactics of it and why she would give this answer. So if she says it's correctly decided, she takes it as a premise. I guess she can say logically it speaks to the home and the home being special. So you got that going for you. But when you're in the public at large with other people, then it raises different issues. So I mean, you can have your cake and eat it too. It's just interesting that she didn't say, I disagree with Heller, but I recognize it's the precedent. And as the precedent, it speaks to the home, and this is not the issue here. So I don't think Heller has anything to say about our issue, which would also be a fair response. There's a tactical reason she gave that response. It's interesting to consider what it is. I'll have to ponder that a little bit more.
there was an argument on the other side too, but that's true about maybe most of the difficult questions that come before this court. I have no quarrel with Hill.
Do you think that we are bound by the way that we characterized history in that opinion? You know, Mr. Clement has pointed out that in some respects the way that we treated, say, the Statute of Northampton and is different from the way that you argue that we should interpret that and the follow-on, statutes in the colonies. You argue that we should understand those in some other cases differently than we did in Heller. Are we free to do that?
I think you are, because I think the Heller decision made very clear that it was not deciding anything other than the right to keep arms in the home. In the course of arriving at that decision, it necessarily said a lot of other things that led to that decision, but I don't think they are controlling, or I think the opinion itself says we're not trying to do a full exegesis of the whole Second Amendment right, and there's more to be done, and it would be odd and really inconsistent with general practice to treat every sentence or every reference to a historical source as controlling for all time, as distinguished from for the purposes for which it was invoked.
Thank you, General.
Thank you, General.
All right, so not a great argument. It's serviceable. It's serviceable, but you'd expect a little bit more from the U.S. at the U.S. Supreme Court. So it's not horrific, but her lack of confidence and seeming lack of preparation is a bit unusual. Although, to be quite fair, we've seen far worse at the U.S. Supreme Court. Far worse. For any people who know anything about our Supreme Court React series, we've seen some real train wrecks from time to time at the U.S. Supreme Court. So she's by no means the worst. I'd say she's okay. I expect a little bit more, but it's serviceable. She's no Paul Clement, that's for damn sure, but she's by no means the worst. So, not great, but I don't think it's going to get her where she needs to be. So now that we've reached the end of her portion of the argument, let me do some super chats and some questions from the bot. So here are some of the super chats you've been providing me. All super chats will be read out, and other questions will be answered as appropriate. $10 from Mandarake says, so the Second Amendment argument is around what the definition of arms is. It's more about it's partially about what the definition of arms is, but it's more about what the right to keep and bear arms is. What is the right, rather than what the arms are. You have to start with, what the contours and boundaries of the right are, and that it's probably a more primary thing than the nature of what arms are protected. But maybe that's kind of the same thing in the end, but I think the word "the" is more important than the word arms. AF gave $5, said Article 1, Section 8, Clause 8, letter marquee implies private ownership of warships capable of leveling cities. I don't tend to agree with that analysis, but it would certainly authorize Congress to make private ownership possible, but I don't think it implies that. Also, a letter of marquee is something Congress can do, not something they have to do. So I don't think you can get to where you want to be from that. Mithrin Emrys says, law enforcement will respond. What's the average response time for New York police? By the time they respond, the need to protect is long over. Truth. Mithrin Emrys says, okay, granting her argument about urban versus rural, I more likely need a gun for self-defense in urban area than rural. Very true. Federan Thomas became a new member. Thank you for becoming a member, and you get the cool little icon by your name. Little scales of justice by your name for becoming a new member. Thank you. IBL whatever says, could you read, summarize, and give your input faster than listening word for word? JW. Either way, you do you, obviously. First, I'm not sure what JW means, but in question 2, could you read, summarize, and give your input faster? Yes, I could, but that's not what we do in the Supreme Court React series. So in the Scottish React series, and we have lots of videos on this in the channel, but in the Scottish React series, we go through it word for word. We listen to the entire oral argument. It's what we do. We listen to the entire oral argument, try to really understand the legal issues that are confronted, try to understand what is being said, try to look for the good points of advocacy, try to look for the bad points of advocacy, because it's our opportunity. Oh, JW is just wondering? Okay, yeah. So it's our opportunity to because the Supreme Court, hopefully, and not always, but the Supreme Court hopefully is the absolute elevation of law, at its best, right? So, sometimes we get some really outstanding performances and really outstanding analysis of law. And so it's our opportunity to really see law argued at its highest level. It's the Super Bowl, man. It's the Super Bowl of law. So we take our time and we really look at it and see what we can learn from it. So that's what we do, man. Tim Green says there's no amendment creating the Supreme Court. We don't need an amendment. It's in Article 3 of the Constitution. Article 3 of the Constitution literally refers to the Supreme Court. Go read it. And there is value in hearing it as well. Absolutely. You get to hear the tone. You get to hear the questions. You get a lot more from the audio, I think, as well. Let me go through some of your questions that the bot has been capturing. Won't necessarily answer them all, but I'll answer the ones that look interesting. Uncivil law. One could argue the Supreme Court says the people have the right to keep and bear arms, not each person. The individual right is arguably a recent invention by the Supreme Court. You'd have to go back further than that. I mean, other parts of the Constitution have long... the individual right going back, you're going back to at least... late 1930s, if not earlier than that. So you're having to quibble with quite a lot of history at this point. JTZKB says, without an amendment, couldn't Supreme Court simply do away with the individual right to keep and bear arms the court arguably created? Scott says the right of the people, not the right of persons. Yeah, but the right of the people also appears in other parts of the Constitution and has been interpreted in other parts of the Constitution, and so the Second Amendment phraseology is understood in the same vein. So you're not trying to just overturn the Second Amendment, you'd be trying to overturn quite a lot of case law to go down that road. Tan Dodd says, wasn't determined by a federal case in Los Angeles, the police have no duty to come to your aid. Yep, they sure do. There's a couple great cases on point. Castle Rock versus Gonzalez, DeShawnee versus Winnebago, and Warren versus DC are three really great cases that stand for the proposition the police have no duty to come to your aid. So, yep. JTZKB says, do all states have the exact same legal definition of libel slander? No, they don't. They all differ from each other. They're similar enough that I can talk about them all in the same breath without being misleading, but there are nuanced differences between them. So, yeah. Terry says, isn't it extremely bad conduct to interrupt a judge, let alone a Supreme Court justice? Yes, it is. You know, when you're dealing with the exchange, yeah, you need to shut up when the judge starts talking. But, you know, you're on a limited time, and so you sometimes try to squeeze out the end of your thought at the Supreme Court. But that's just kind of how that flows. Joe's Med said, it seems Alito is suggesting that she wasn't deliberately misleading, but rather made a mistake. Yeah, but then she kind of doubled down on it, so yeah. Melanie said she didn't say it was rightly decided. She said she's content to treat it as if rightly decided. Maybe she chose those words very, very carefully. That's fine. I didn't split that difference, but maybe you're right. Mikkel says, what's your ideal interpretation of the Second Amendment? That's a really hard question to answer simply, but I looked at parallels from the First Amendment in terms of trying to answer that question. Okay, so that is the end of the questions from the bot and the end of the super chats. And then IBL said Breyer sounds like Thomas Sowell. Maybe he does sound a little bit like him. All right, so next up, and for our final participant in this, and then there's going to be a rebuttal time. But for our final participant, we have the United States arguing on behalf of New York. So the United States would like to also offer its thoughts in support of New York, and I would imagine this is going to be better than the Solicitor General from New York, but we'll see.
Mr. Fletcher?
Thank you, Mr. Chief Justice, and may it please the Court. New York's proper cause requirement is consistent with the Second Amendment because it is firmly grounded in our nation's history and tradition of gun regulation. Now, as Justice Alito said, there's a lot of history floating around this morning, and so I want to be clear that when I say that, I am putting to the side all of the disputed bits about the Statute of Northampton, about the surety laws, and I'm putting to the side laws that restricted concealed carry but did not restrict open carry. And I am focusing on laws that either prohibited or required a showing of good cause to carry a concealable weapon like a pistol. Tennessee enacted one of those laws in 1821. Texas followed in 1871. New Mexico and Arkansas likewise enacted such laws in the years immediately after the ratification of the 14th Amendment. And over the decades that followed, more than a dozen other states enacted other laws that were at least as restrictive as New York's. Like my friends from New York, I count about 20 laws in total that fit that description. Those laws remain in force in 7 states today, and more than 80 million Americans live under their protection. They are, in short, both traditional and common regulations. I'd welcome the Court's questions, or I'm happy to continue.
All right, a very short, punchy opening. It's very, it's just very clear, right? So he's trying to extend the time, right? So he doesn't want to go back to the founding of the Second Amendment. He wants to go back to the 14th Amendment. And he wants to bring in this, and he says, okay, at the time of the 14th Amendment, and in the immediate aftermath, there were, what did he say, 20 laws of the same nature? So he's saying, well, these kinds of restrictions were well understood at the time. This is part of the original public understanding of the Second Amendment. So he has a problem if you're going to go all the way back to the founding of the country, because you don't have the same restrictions. But if you're going to go to the 14th Amendment, which would seem to be improper, based on how the Supreme Court treats other constitutional rights. Because normally you go all the way back to the founding of the country rather than do this later thing. But he's trying to protect that ball. Really short, really punchy. It's like, I'm only going to defend this piece of ground. All right. I mean, fair enough. Let's defend that piece of ground.
How do we determine which states we should look to? You focus a lot on Western states, but the West is different. Right?
I agree, Justice Thomas, and I think there might be reason to be skeptical about a tradition that's only reflected in one state. I think that's a problem for Mr. Clement in relying on some of the cases exclusively from the antebellum South. But the cases that we're relying on come from the South, like the Tennessee, Arkansas, and Texas law I described. West Virginia had a similar law, as did Alabama, New York, Massachusetts, California, Hawaii. The tradition that I am drawing on spans 2 centuries, going back to the Tennessee law, spans 150 years when you broaden it out to many states, and spans all regions, or virtually all regions of the country. So I think that's the sort of tradition that you can look to when defining a national tradition of gun regulation.
But, I mean, what is the appropriate analysis? I mean, you sort of, we I think, generally don't reinvent the wheel. I mean, the first thing I would look to in answering this question is not the statute of Northampton, it's Heller. And Heller has gone through all this stuff. And obviously in a somewhat different context, although that's part of the debate, self-defense at home, this is different. But I still think that you have to begin with Heller and its recognition that the Second Amendment, it has its own limitations, but it is to be interpreted the same way you'd interpret other provisions of the Constitution. And I wonder what your best answer is to the point that Mr. Clement makes in his brief, which is that, for example, if you're asserting a claim to confront the witnesses against you under the Constitution, you don't have to say, I've got a special reason. This is why I think it's important to my defense. The Constitution gives you that right, and if someone's going to take it away from you, they have to justify it. You don't have to say when you're looking for a permit to speak on a street corner or whatever that, your speech is particularly important. So why do you have to show, in this case, convince somebody that you're entitled to exercise your Second Amendment right?
So let me start with the general question and then get to that specific point from Mr. Clement. As to the general question about Heller, we agree completely that the Court ought to apply the method from Heller, which we, like I think all the parties, take to be look to the text, history, and tradition of the Second Amendment right. And we're applying that now to a somewhat different issue with the benefit of somewhat broader materials. Now, as to the question about why do you have to have a showing of need, I think the problem with Mr. Clement's formulation is that it assumes the conclusion. If you had a right, the Second Amendment conferred a right to carry around a weapon for possible self-defense just because an individual wants to have one available, then obviously you couldn't take away that right or make it contingent upon a discretionary determination. But the whole question is whether the Second Amendment right to keep and bear arms confers that right to have a pistol with you for self-defense, even absent a showing of demonstrated need.
I'm not sure that's right. I mean, you would, regardless of what the right is, it would be surprising to have it depend upon a permit system. You can say that the right is limited in a particular way, just as First Amendment rights are limited, but the idea that you need a license to exercise the right, I think, is unusual in the context of the Bill of Rights.
So I agree with that, but I think I heard even Mr. Clement in response to a question from Justice Kavanaugh say he doesn't have a quarrel with licensing regimes in general. And I think what that is one illustration of is that the Second Amendment has a distinct history and tradition, and that the way to be faithful to the Second Amendment is to be faithful to that history and tradition and not to draw analogies to other rights with their own histories and traditions.
Okay, this is nice too. So he's trying to keep it to the Second Amendment, which is a perfectly fair thing to do. So he's saying, look, it's not faithful to look at the First Amendment by analogy. Okay, I mean that's a reasoned argument. So Mr. Clement said apparently he doesn't have a quarrel with licensing schemes in general, which is what he said, right? Because his only problem is the fact that it's being denied on these sort of arbitrary grounds, not licensing in general. And so he's saying, look, you have to look at this from the particular view of the Second Amendment and its history and tradition, which includes these kinds of restrictions, which he says has 150 years worth of history, which I suppose it is, depending on, how you're counting this. But yeah, if you're going back to, 1860s, then yeah, you get about 150 years worth of history, give or take, sure. So he says, look, you got to look at this whole history and what applies to the Second Amendment. So he's trying to separate the Second Amendment from the other amendments, and he's doing it in a way that's intellectually honest. So I appreciate that.
There's licensing and there's licensing. Maybe it's one thing to say we need to check, make sure you don't have a criminal record, make sure that all the other things you can check on, but not that we assume you don't have a right to exercise your
So I guess
it's hard to say it without saying it, with exercise your right under the Second Amendment, and you've got to show us that you do.
So we would ask that question by looking to the history and tradition of the Second Amendment. And in Tennessee in 1821, you couldn't carry a pistol at all. In Texas in 1871, you had to have a showing of need if you were going to carry a pistol. And that showing of need was actually much less favorable than the New York regime. In Texas, in West Virginia, and in Alabama, in those laws that we cite, need to carry a firearm was a need that you had to show when you were prosecuted for violating the law. It was essentially a self-defense requirement, and you had to persuade a jury in a criminal trial that you had an immediate pressing need to be carrying the gun when you were carrying it. The laws, of which New York's is one, but by no means the only example, that began to become more prevalent in the 20th century, said, we're going to make that determination of need ex ante. We're going to require a showing of good cause. New York has done that for a century. I'm sorry, Justice Kavanaugh.
This might be a level of generality issue, but I think Mr. Clement responded to some of what you're saying on history and tradition by saying you have to look at carry laws more generally. And there was open carry traditions in a lot of those states. And so that I think he followed up by saying, so open carry is one option, shall carry permit regimes for concealed carry another option, but what you can't have is no open carry and simply a may issue discretionary regime that will, in practice, he says, limit the rights. So can you respond to that?
Yeah, I meant to be taking that into account in the account of history that I'm giving you. So the Tennessee laws refer specifically to carry publicly or privately. Texas, the same story. If I were here defending a regime that just prohibited concealed carry and allowed open carry, I would have many, many, many more states. But I'm focused on just this type of law, and even there, our submission is there's a substantial history and tradition of that kind of regulation. It's not the sort of outlier that the court confronted in Heller and McDonald. And if I could speak to, Mr. Clement has spoken some about the case law from the 19th century and has suggested that laws like these were struck down. And with all respect to my friend, that's not correct. The cases that he is relying on are primarily dicta. The two cases he has that actually struck down laws, the three cases that he has that actually struck down laws are the Nunn decision from Georgia, which struck down a law that was banned even the keeping of pistols. The court did say in dicta that open carry was required, but the law was actually much more restrictive than that. The Andrews case that he relies on and that Heller relies on as well is actually more helpful to us because the court upheld a prohibition on the carrying of belt or pocket pistols. And it prohibited a ban on revolvers only because the court construed that ban to be so broad that it would prohibit even carrying it around your house. And in the very next sentence, the court said, but of course the legislature, if it wanted to, could regulate the carrying of that firearm publicly. And then when you turn to laws like the ones that we have here, which include some sort of self-defense exception, either ex ante or ex post, the trend in the cases is in favor of upholding their constitutionality. We've cited about 6 decisions from the 1800s and the early 1900s, including the Duke and English cases from Texas, the Isaiah case from Alabama, the Haley and Fife cases from Arkansas, and the Workman case from West Virginia, all of which upheld those laws. And Mr. Clement's answer to those decisions is that they rested on the erroneous understanding that the Second Amendment or its state equivalents protected only the right to use arms in the militia. But that is not what those cases say. They do not stop by saying that the defendants were not militiamen and so had no rights.
All right, so just for my money, you obviously don't have to agree with what he's saying, but for my money, this is a very good advocate, and the way he's advocating is very intellectually honest. I find his argument to be logically coherent, and he is arguing a position, and he's arguing it extremely well. So first of all, he says, okay, all I'm going to do is talk about restrictions of the same kind in New York with respect to concealed carry in particular. So I'm not even going to talk about all the places that banned concealed carry because they allowed open carry. I'm just going to talk about places that banned that regulated concealed carry in the same way of New York. So he's saying, okay, first of all, I've got 150 years worth of cases. I've got cases from all these places. I got cases from Hawaii. I've got places from Texas. I got places from Alabama and so forth, either prior to the 14th Amendment or around the same time of the expedition. He then says, okay, then he says, well, my friend on the other side has said that some of these cases were struck down, and actually, no, not so much. They weren't. They were only struck down for other reasons. Like, for example, this one case where they said explicitly that the legislature could ban carrying in public. The reason they struck it down was because they read it so broadly as to apply in the home. But they said, yeah, it's no problem if it was a properly constructed law. And so he's citing all this specific authority. He's citing all this specific authority that he thinks stands for these propositions. So he cites these cases. 6 cases from the 1800s and 1900s, Duke and English cases from Texas, Isaiah from Alabama, Henley and Fife from Arkansas, Workman case of West Virginia. And Mr. Clement's answer is that they rested on this erroneous understanding, but that's not what the cases say. They do not stop by saying the defendants were not militiamen and so had no rights. So I really, really like the intellectual honesty of this argument. You know, we had this in Tennessee, we had this in Texas. It's not an outlier like it was in Heller and McDonald, where, you know, DC banned basically all pistols and was a complete outlier. It's like, no, this isn't an outlier. This is in conformity with a lot of states. We can find lots of specific authority that stands for these propositions. So, again, this is a really good advocate. I really like what he's doing here on an advocacy level. He's found cases that he believes supports it. He's representing them in a very clear, very understandable way, and it's logically coherent. It flows from the conclusions that he's trying to get. So it's a very good argument, and I appreciate that. Unlike the Solicitor General from New York, who had no confidence in her argument, it was poorly organized. He has strong confidence in his argument. He represents it strongly. He represents it specifically. It's not obscured. It's not hemming and hawing. He's like, here's the specific things. Here's the specific dates. I think I've got it. So, you know, there's some good stuff there. I really like this argument in terms of what it's trying to do. And if you're going to be a pro Second Amendment guy, you want to stand for gun rights, you got to really kind of think about this. You really got to kind of confront this. You got to come up with a good answer. And the good answer is not, but shall not be infringed though. So let me just help you out. That's not going to cut the mustard to this. You have to be better than that. And Paul Clement is better than that. So he has some good answers, but you got to be prepared to actually deal with this shit. So I appreciate what he's trying to do.
The Texas cases in particular, in Duke and English, say that the law makes all necessary allowances for self-defense by including the type of exception we described earlier. And so our submission is that that body of case law that New York law carries forward is part of our nation's history and tradition of firearms regulation, and that New York ought to be allowed to continue to make the choice that it has made. Now, we understand, and there's force to Mr. Clement's argument, that other states have made other choices. Justice Alito made powerful points about how some individuals have a powerful claim to have a gun for self-defense. But the question before the court is, of all of the different approaches to these difficult issues that states and other jurisdictions have taken over our nation's history, is this one that the Second Amendment takes off the table? And our submission is that when it's an option that New York and other states have had for a century or more, and that traces as far back as some of the laws that I've been discussing into our nation's history, that's an option that is consistent with our tradition of gun regulation and is an option that ought to be available to the states.
Yeah.
Justice Thomas?
I like this a lot better than what they came with. I like this a lot better than what the dissent came up with in Heller and McDonald. I'll tell you for damn sure, I like this a lot better. This is an intellectually consistent argument. There are ways to beat this argument. You know, Paul Clement has ways to beat this argument, but I really, really like this argument. So unlike the dissent in Heller and McDonald, where I thought it made no sense really at all, because it just was like, what is going on? This argument makes a lot more sense. So if you base a dissent based on this kind of reasoning, it's a lot more intellectually pure, because you can argue it from within its own terms, right? The right to keep and bear arms. What is the right to keep and bear arms? Okay, how do we determine that? Well, one of the ways we do that is by original public understanding. Great. What is the original public understanding? And we say, well, we have 150 years worth of law. Now, that only gets you back to around, so you have Tennessee, which has it in 1820. Otherwise, you're around the same time as the 14th Amendment. It's Texas 1863, I think he said. And so that's right around the same time as the adoption of the 14th Amendment, and then the other stuff. But it's like, these are valid policy choices. So the way to beat this argument is be like, well, the actual thing we should be trying to understand is the Second Amendment as it existed in 1791, not 1868. And so these regulations are, and of course you can also point to, quite honestly, the fact that a lot of these regulations are coming around as a result of Jim Crow, and so at least in part, although Tennessee seems a little early for that. But this is an intellectually honest argument. It's like, well, the Second Amendment needs to be understood on its own terms. These regulations go far deep and wide by a lot of states in a lot of areas, including states in different geographic areas. And so these kinds of regulations are well within the keeping of the Second Amendment. And then he asked the question, so like, does the Second Amendment take this off the table in face of all these things? It's a good argument.
Justice Breyer, Justice Alito.
Is it correct that the Sullivan Law was an innovation when it was adopted?
It was relatively new. I think the Sullivan Law was 1911. The licensing requirement at issue here was 1913. I think Massachusetts had done something similar in 1906. Hawaii did its as well in 1913, and we view those as lineal descendants and, in fact, improvements upon the sort of Texas laws, which made you prove self-defense at the back end rather than giving you a chance to demonstrate it up front.
There's a debate about the impetus for the enactment of the Sullivan Law, is there not? There are those who argue, and they cite support for this interpretation that a major reason for the enactment of the Sullivan Law was the belief that certain disfavored groups, members of labor unions, blacks and Italians, were carrying guns, and they were dangerous people, and they wanted them disarmed.
There have been those arguments made, and there's certainly evidence that those sentiments existed in New York at the time. I have not seen things that persuade me that those were the impetus for the Sullivan Law, and to the extent that that was a question, I think the fact that similar laws have been enacted and maintained, not just in New York and not just at that moment in time, but in a number of different states throughout the country, throughout large swaths of our nation's history, is a good reason to believe that this is not just prejudice, that this is a legitimate regulation.
Good for him. So he's trying to, he gets in front of it's racism. So they ask about Sullivan, which is New York. New York's restrictions on guns are called Sullivan Law. So yeah, it's like, does the New York regulations have racism behind them? And he's like, well, there's certainly some sentiment of that at the time, but there's no particular evidence of it for Sullivan Law. And even if you could, this is a lot of places, a lot of times, and so it's not just prejudice; it's legitimate regulation. He knows what he's doing. He knows what he's doing. You don't have to like him. Well, I think you should like him as far as an attorney. Let me put it differently. You don't have to agree with what he's saying. You can think that that the other side has the better end of the argument, but I think you'd be foolish to not try to learn from this guy in terms of argument. His argument style is solid. He's a masterful presenter. He's equal to the task with the opposition, and that certainly can't be said for a lot of people when it comes to Paul Clement. This guy is really solid. Any law students out there, this is masterful. And if you're not appreciating it for its construction, its honesty, for its persuasive power, I don't know what to tell you, because it's really good. There's a lot of reasons to disagree with it legally, but on its own terms, it's really solid.
I think one more question about the major point that you've made this morning, which is that there are scattered statutes, local ordinances, judicial decisions from various points in the 19th century, extending into the 20th century, the early 20th century with the Sullivan Law, and the other laws that you mentioned that are inconsistent with Mr. Clement's argument. But what does that show about the original understanding of the right that's protected by the Second Amendment? Would we be receptive to arguments like that if we were interpreting, let's say, the First Amendment or the Confrontation Clause of the Sixth Amendment? Would we say, well, you can find a lot of state laws and state court decisions from the 19th century, early 20th century that are inconsistent with a claim that is made based on the original meaning of a provision of the Bill of Rights, and that shows that's what that was understood to mean at the time.
Well, Justice Alito, I think Heller was receptive to those types of arguments and conducted a review of history through the 20th century, and rightly so. I think it's not unusual to look to the nation's tradition to understand the meaning of constitutional rights. I think that's especially appropriate here for a couple of reasons. One is that I think everyone agrees that the right codified in the Second Amendment is a right that is subject to some reasonable regulations, and in deciding what regulations are reasonable, we think the fact that they've been prevalent throughout our history is a good sign that they are. We think that's especially so because of a point that this court made in McDonald, which is that throughout the nation's history, this is a right that's been recognized and codified in state constitutions as well. It's not something that people were not aware of. And so the fact that this type of regulation coexisted for so long with that understanding, we think is a particularly strong indication of its consistency.
Well, Heller, and I will stop after this, Heller cited decisions going into the 19th century as confirmation of what it had already concluded based on text and history at or before the time of the adoption of the Second Amendment. It said this is what it was understood to mean at the time, and it's further evidence that this is what this right was understood to mean because it kept being reaffirmed by decisions that came after. But I find it hard to understand how later decisions and statutes, particularly when you start to get into the late 19th century and the early 20th century, can be used as a substitute for evidence about what the right was understood to mean in 1791 or 1868 if you think that's the relevant date.
So you're certainly right about the way that Heller looked to decisions on its core holding of does the Second Amendment protect only a militia-focused right or an individual right. But when Heller turned to the question presented here, which is what sorts of regulations are consistent with the right that it was recognizing, I think it's fairly read to extend the analysis into the 20th century for the reason that Justice Kagan identified, that it validated as presumptively lawful felon in possession requirements, bans on the possession of firearms by the mentally ill that date to much later than the 19th century.
Thank you. Justice Sotomayor?
What do you do with Heller and its recognition of categories of exclusion? Mentally ill, felons, domestic violence, presumably, although it didn't mention it. Can any of those ever pass strict scrutiny on their face?
I don't know. I think the lesson from Heller, though, is that you don't need to apply strict scrutiny or any other level of scrutiny because those are the types of regulations that are validated by our nation's history and tradition of gun regulations. And so we would take that lesson from Heller as exemplifying the proper mode of analysis and apply it here as well.
So what do you do with the view, Mr. Clement's view, that the essence that Heller says is that you do have some sort of right outside of the home to guns for self-defense. So how do you finish what you think that right is, or how do you describe it?
So we don't quarrel at all with the notion that the Second Amendment has something to say outside the home. Our submission is just that to understand how it applies outside the home, one has to look to the history and tradition of regulations. And what we've tried to argue in our brief and this morning is that there is a substantial history and tradition of the regulation of the public carrying of concealable weapons, including pistols, because of the dangers that they present. And that regulations of that type, of which New York's is one, are consistent with the right recognized in the Second Amendment.
Let's go to the extreme. There's no exception for a good cause. There's no exception for no exceptions whatsoever. No rifles for hunting, nothing. Outside the home, you can't possess any kind of ammunition-driven weapon.
Yeah.
Where would we be with that?
I think that is a type of regulation that fortunately no state has today and that I don't think there's any historical precedent for. I don't think you could make this sort of argument for that sort of
give me the limiting principle of what regulations and how far they can go that don't achieve that.
Well, I don't know that I could give you a limiting principle if you ask me this question, and we'll look at his answer. it's not as simple as a limiting principle. But I mean, the answer is the answer is a little unsatisfying, but it's we look to history for those answers. So in the same way, the First Amendment has its limiting principles, such as defamation and fighting words and true threats, we would look to history for the limiting principles of the Second Amendment. So it's not just one simple thing I can give you, but you would look to the history of the right as it was understood, which is, look at all, like English common law, for example, and look at the right and look at things that are contemporaneous. And, it's not a simple answer, but it's doable. So I'm not sure he's going to be able to give a tight answer, but we'll see.
Right. So I think, like Mr. Clement, it's going to be difficult for me to give you definitive answers because, in our view, this is an inquiry that has to be driven by history and tradition, and that requires a careful examination of history and tradition. But let me give you a couple of guideposts. I think there is a tradition of laws like the Tennessee law that I alluded to earlier and others that prohibit the carrying of concealable weapons without any exception for self-defense or any good cause exception like the one that you have in the New York law. So we think, and Judge Bybee for the en banc Ninth Circuit concluded after an exhaustive historical analysis, that those types of regulations are consistent with the Second Amendment. But I acknowledge that that's a tougher historical case to make than the case that you can make with respect to laws like New York's that include self-defense exceptions.
Thank you.
Justice Kagan?
Mr. Fletcher, I think I probably should have asked General Underwood this question, but I forgot, so here you are. And the United States also has law enforcement officers, even though they operate differently from sort of the cop on the beat. But I'm just wondering if there is anything that you could say, any evidence that you can share. Are there studies? Is there information about how this actually affects how getting rid of this regime in the way that Mr. Clement would want this court to do, how it affects policing, how it affects the ability of police officers to keep the streets safe, and how it affects their own safety. Is there information about that? Are there studies?
There are. I think the best place I can point you to for studies are some of the amicus briefs, including the social scientist brief that Justice Breyer discussed with my colleague, General Underwood. In terms of sort of the United States' perspective specifically, I don't have any sort of quantifiable statistics. What I can tell you is that we do share the concern behind the New York law, which is the concern that having more guns on the street does complicate and increase the danger inherent in citizen law enforcement encounters. We do think that's a real concern, and it's one of a number of real concerns that are reflected in the law that New York
do police officers stop people in the same way in notwithstanding what whether there are whether it's a New York regime or a more permissive regime?
I apologize. I don't have studies on that. All that I can give you is my own sense that if I were a police officer, I would certainly think prominently in my mind about what are the odds that the person that I'm stopping or approaching on the middle of the highway, late at night, is likely to be armed, and the licensing regime in the state is going to be an important factor in the risk that that's the situation.
Thank you.
Justice Gorsuch?
Mr. Fletcher, in your brief, you suggest that the New York law passes both the text and history approach and an intermediate scrutiny. Should we apply that? And I guess I'd like to pose the same question to you that I did to Mr. Clement, and that is, what is the appropriate test between those two or others? The lower courts seem very divided over how to approach Second Amendment questions. Some apply the text and history approach to the challenge before them. Others say, yes, text and history is appropriate, but we're not going to extend the Heller right until and unless the court first does so through its own text and history analysis. We're not going to do it ourselves. Others have applied intermediate scrutiny. Others have applied what might be described as a watered-down version of intermediate scrutiny. And some have suggested strict scrutiny or some modification of it should apply. I'd just be grateful for your thoughts.
I appreciate the question, Justice Gorsuch. And I think our view is that courts ought to follow what we understand to be the lesson from Heller, which is that you start with text, history, and tradition, and when those sources provide you an answer one way or the other, either that the law is valid or that it's invalid, you end there, and that's the end of the inquiry. We take that approach to be consistent with the approach described by Justice Kavanaugh in his dissent in Heller 2. I think the one place where we might differ from him a little bit is that we think there may come a point, especially as when courts confront new regulations, where history gives out, where it's not possible to draw those historical analogies anymore. And at that point, our suggestion is that the way to be faithful to history and tradition is to look to the broader method that you find in that history and tradition, and the method that we find in a half dozen or so cases from the mid-1800s that we cite is to ask whether the law is a reasonable regulation. And as we explained in our brief, we think that the modern judicial method that is most faithful to that approach is a form of intermediate scrutiny.
Thank you.
Justice Kavanaugh?
Thank you. Mr. Fletcher, appreciate your focus on history and tradition and want to explore that and get your thoughts on one thing. As you say, there is a history and tradition, and it exists to the present day of permitting regimes. And so the issue before us will have effects, but it's a narrow legal issue of shall issue versus may issue, and it'll have substantial effects. But there is a tradition of permitting regimes. But how do we think about, do you think, kind of a separate tradition that the Chief Justice and others have referred to in our constitutional law of concern about too much discretion in exercise of authority over constitutional rights, and the too much discretion can lead to all sorts of problems, as our history shows. So you've got the tradition of permitting, but how do we think about, fold in just a general concern about too much discretion?
So I appreciate that concern, and I think here's how I would think about it. First, I would say there is a substantial history of discretion in this particular area, starting out with juries in the Texas and West Virginia type regimes that I talked about now, moving into permitting officers. And I think that's inherent in any system. If you say a permit is going to be conditioned upon a showing that you have a genuine, specific need for self-defense, then someone's got to make the decision about whether or not you've made that showing. New York has decided it's best to do that by delegating the authority to local officers, local judges who are most familiar with local conditions. I do appreciate the concern about discretion, and I think if the court were to conclude that some sort of good cause, sort of self-defense-based exception is required, then the court might conclude that some more predictable or stringent or prescriptive guidelines are required, that you can't have that much discretion if the court concludes that that sort of good cause exception is actually constitutionally required.
Thank you. Appreciate it.
Justice Barrett? Thank you, counsel. Rebuttal, Mr. Clement?
Thank you. Good. Really good argument. Really good. Really solid. Really good, solid argument. I'll just read this one super chat and then I'll do some questions at the end. But Johnny Face says, I appreciate his clear, confident presentation, response to questions. Rather one agrees or disagrees with the contents, refreshingly non-silently. I couldn't agree more, my friend. It is a masterful argument. It's well done. It's certainly something that can be disagreed with. The easiest way to disagree with it is by simply saying you're looking at the wrong time period. It's 150 years of tradition, which, fair enough. So you're getting back to, 1860s. But it's the wrong time period. You have to look at 1791. That's when because the 14th Amendment simply incorporates the Second Amendment, doesn't change it. And these longstanding regulations, are fun and interesting and all, but they're not relevant to the understanding. And that's not the easiest thing to make, but his argument makes perfect logical sense. And you can find other, you can't find the restrictions on concealed carry that are analogous to New York before Tennessee picked it up 1820-ish. So you can't find other things like that, but you can find other restrictions. And so you could even say, there's analogous restrictions, because it depends how analogous you think they are. So you can go back even further than that if you're so inclined. So his argument is logical, consistent, well sourced. He's got his cites. He has them down. He knows the dates. He knows the case names. He knows what he's talking about. He answers the questions with confidence. It's a great presentation. It's a really, really good presentation. All right, so let's listen to the rebuttal, and then I'll answer some questions from the bot.
Mr. Chief Justice, just a few quick points in rebuttal. First of all, I want to highlight that when the government was asked for its interest behind this permitting regime, it said that if it went to a different regime, it would multiply the number of firearms in circulation. In a country with the Second Amendment as a fundamental right, simply having more firearms cannot be a problem and can't be a government interest just to put a cap on the number of firearms. And that just underscores how completely non-tailored this law is. It might be well-tailored to keeping the number of handguns down, but it's not well-tailored to identifying people who pose a particular risk or anything else because it deprives a typical New Yorker of their right to carry for self-defense. Second point I want to make is just about population density. There's been a lot of discussion about that, but it's very much a double-edged sword because when there's a population density, that's an awful lot of people who all have Second Amendment rights. And so you can't just simply say we're not going to have Second Amendment rights in the areas where there's dense population. And I would say here experience does tell you a lot. By my count, 7 of the 10 largest cities in America measured by population are in shall-issue jurisdictions. And I've mentioned them, cities like Phoenix, Chicago, Houston. These are large cities where it hasn't been a problem. If you want to look at the empirical evidence, and I know, Justice Breyer, you asked about this, please also look at the English brief on the top side, because it's a very rigorous statistical analysis that shows that as a matter of actually doing statistics right, there's no difference here. And what the only difference you really see is that people who have a handgun for self-defense end up with a better outcome. They're not shot. They're not made victims. But the English brief, I think, is really worth taking a look at. I want to say a quick word just about permitting. There may be limiting permitting in other contexts, like parade permitting, but I'm not aware of any context whatsoever where in order to get a permit, you have to show that you have a particularly good need to exercise your constitutional right. And I think that is the absolute central defect with New York's regime here. I want to say a quick word about the history that my friend from the Solicitor General's office emphasized. It's telling that his first example is Tennessee. If you look at the Heller decision, Tennessee is a problematic state in terms of its history. The court that Tennessee Supreme Court first came out with the IMET decision, which the majority opinion in Heller criticized. It then came out with the Simpson decision and the Andrews decision, both of which protected Second Amendment rights, and the majority opinion in Heller praised those decisions at the same time that it criticized AMET. So to the extent there was an 1821 statute, I would put it in the same box as the AMET decision. Texas, which is their next example, and their only other 19th century example, if I heard my friend correctly, is even more problematic to rely on because Texas had a specific constitutional amendment that was similar to the English Bill of Rights but different from the Second Amendment that allowed the legislature to put specific restrictions on the right. So relying on 1871 Texas is highly problematic from a historical perspective, and that just leaves them with 20th century examples, which we concede, but by that point, the collective rights view of the Second Amendment was everywhere. Let me finish just by saying there's absolutely no need for a remand here. There are interesting statistics that could be developed, but none of them are relevant to the two central defects in this regime. First, that in order to exercise a constitutional right that New York is willing to concede extends outside the home, you have to show that you have an atypical need to exercise the right that distinguishes you from the general community. That describes a privilege. It does not describe a constitutional right. That is a sufficient basis to invalidate the law, but then there's the discretion. And the discretion here has real-world costs. If you want to look at it, look at the amicus brief in our support by the Bronx public defenders and other public defenders. The cost of this kind of discretion is that people are charged with violent crimes even though they have no prior record just because they're trying to exercise their constitutional right to self-defense. And if you want to know how this impacts policing, one of the way essentially making everybody in New York City a presumptive person who is unlawfully carrying is that leads to stopping and frisking everybody. The framers, I think, had a different vision of the Fourth Amendment and the Second Amendment, and that is that individuals get to make their decision about whether or not they want to carry a firearm outside the home for self-defense. In 43 states, people are able to do that. It doesn't mean everybody ends up carrying, and it doesn't mean that those 43 states have any more problems with violent crimes or anything else than the 6 or 7 jurisdictions that don't honor the text, the history of the Second Amendment, and Heller. Thank you, Your Honor.
Thank you, counsel. The case is submitted.
Shit, dude, that's why Paul Clement is one of the best. That's why Paul Clement's one of the best. Shit, dude. Man. That's why Paul Clement's one of the best. I can't do that. I can't do that even in my dreams. I can't do that. It's just too good. He responds to all the points. It sounds prepared, and maybe it is, but he's also responding to specific points of the other argument, and he certainly read their briefs and stuff, but he can't know what they're going to argue exactly, but he seems to have it just, well, it sounds planned. I can't do this. I can't do this. I'm not this good. But then again, no one's this good because it's Paul Clement, and he's goat. No one is this good. No one is this good. But it's a thing to behold, man. That's just that rebuttal was pretty damn good. Pretty damn good, man. Jesus Christ. Even in my dreams, I'm not this good. I know I keep saying it, but it's just a thing to behold. It's wow. Wow, I'm going to have to listen to that again at some point, and I suggest you might want to too. Let me do some super chats that came in. $5 from Liberty or Death. The conservative law student here. Why did they mention Texas when we're now a constitutional carry state? They're talking about the history, right? They weren't talking about Texas now. They're talking about Texas in what was it? 18 something. The dates are in here somewhere. And they're talking about Texas in 18 whatever. Yeah, so they're talking about Texas regulations in the past. From a historical perspective, what regulations could be done. So they're not talking about Texas now. They're talking about Texas in the past. That's not... 1871. Yeah, 1871. So that's what they're talking about. That's what Texas did in 1871. So they're talking about what historical... Because we're looking at the Second Amendment and what it means. So we looked at history, and so, yeah, here's what Texas did in 1871 to the extent it's informative. 1871. So, yep, there you go. Yeah, Dan Beck says finally someone actually playing 4D chess. Yeah, right? It's like, I can't do this. I can't do this. I can do better than the Solicitor General of New York, I'm pretty sure. I'm not 100% sure I can channel the U.S. government's guy. No, I don't know. I don't think I'm that good. The U.S. government's guy is better than me, and Paul Clement's definitely better than me. It's okay to know your limitations. It's okay to know your limitations. Let me answer some questions from the bot before I gush over it too much more. As Ross said, Your Honor, we're from the government here to help. That's always funny. Marcus says, where are the subpoenas for sitting members of Congress regarding January 6th? First of all, it's off topic. Second of all, I don't know where the subpoenas are. How would I know? Richard Stockton says, is there any evidence that Texas in 1871 pay attention to the law? Yeah. T. Blank says, I hate the argument that various states at various times made unconstitutional laws and those precedents for newer laws as tradition. It's not an invalid line of arguments. Like, this is how the Constitution's understood. Of course, your ultimate rebuttal to that is always the free speech law, the free speech restriction that was passed just after the First Amendment. Damn it. Yeah, but there was a very bad First Amendment regulation that was passed like in 1793 or something. And it was really, really bad. So that's sort of your ultimate rebuttal to that, but it's still a thing. Yeah, Clement would make an excellent defense against the dark arts. Absolutely. Where's the English brief? Oh, all the briefs are on the court's docket, so you can just go to the U.S. Supreme Court docket, and all the briefs are there. Just look up the case name by its name, and all the briefs and documents are there. Alien and Sedition Act, that was the one I was looking for, thank you. Yeah, the Alien and Sedition Act, so that's your ultimate kind of counter. But yeah, if you want to read the English brief, they're all on the U.S. Supreme Court's website. It's an open docket, so no charges or anything. T Blank says he found too many logical fallacies. I didn't really see any personally, but you might have been looking really hard for them. I thought his argument was very good. Kenneth says, what other argument says shall not be infringed? Do you mean using exactly literally those words? None of them do. I'm sure you know. I think the First Amendment's Congress shall make no law is pretty damn close in its construction, but that's my view. Where do I stand on gun rights? I consider myself very pro-Second Amendment, Tim. Boxer briefs, man. Billy says, how much of the case is oral argument versus file brief? Oral argument is very small percentage of the case. The briefs are where it's at. It's probably not even 30-70. It's probably like 10-90. There's a pretty good maxim about the Supreme Court that I believe is true. And that is that you can't win a Supreme Court case in oral argument, but you can lose. You can't win a case at the Supreme Court in oral argument, but you can lose. And we've seen examples of that, in my view. But yeah, the oral argument is probably not going to really push people back, but when you want, especially if you're the Solicitor General of New York, who left a lot to be desired. But yeah, oral arguments are probably 5-10% of the overall case. It's very, very low. If it's a really tight case, if it's really close, if someone's on the edge, then it can move the needle. But mostly it's in writing. The writing is really where it all sits. If your oral argument sucks, though, if it blows, you can definitely undermine your case. Lucifer himself says, 2A has nothing to do with owning a musket or for hunting, but for defending yourselves from anyone, including the government. True or false? I think that's true. I mean, the Federalist Papers certainly reflect that. Do you think that a rule favor for 2A will make unconstitutional ask why you had a gun? No, it's nowhere near that at this point. The case will not go that far. Ryland says, is a suit seeking relief by forcing all states to become shall issue? They're not doing that. They're just merely challenging. They're not doing that. They're just merely challenging the good cause requirement, which I think would effectively make all states shall issue. But they're not going to do constitutional carry. Does a favorable decision for 2A make it likely we'll have national reciprocity? No, not anytime soon. The Oracle says, what got you interested in law? I was interested in law when I picked up a copy of the Constitution in middle school, and I loved it, and it was great. Who's the GOAT Supreme Court judge? Oh, that's so hard. I mean, I could give you like a list. There's so many good ones. I mean, Holmes comes to mind. Scalia comes to mind. Black is a little ordinary, but he can be fun. I think that's kind of the short ones. Brandon says, why are all arguments done through analogy? Well, because either one of two things is true, Brandon. Either you have the answer already, or you need to analogize it to something else, right? So if you already have the answer, then you don't need to analogize it. But if you don't have the answer, then you need to look to your comparables. It's a little bit like asking, why is home pricing determined based on comparables? It's like, as opposed to what? You look to your nearest neighbors and similar sales to determine what a fair market price for a house is. Yeah, if you already know the number for the price because you just sold it, then you know the number, great. But otherwise, how do you determine what a fair price is? Well, by looking to the comparables. and then you make your adjustments from there. It's like, what else can you do? Jim Stellata says the long-standing felon restrictions keep talking about didn't exist till 1960s. I don't know if that's true or not, and to the extent it is true, it's because felons in common law were all capital crimes, so you don't really need to worry too much about felon restrictions when, you know, all felons are dead because you just executed them. Not the hugest Thomas fan, personally, but you know, that's just where I sit. So I think that's going to end the stream for tonight. I thought this oral argument was really good. I mean, what you would be predicting, what you're predicting is the Supreme Court to say something like, you can't restrict the right to bear based on an arbitrary, capricious reason like, you know, good cause. You know, you can restrict it based on universal rules that apply as long as they're not overly onerous, and also something about the history, text, and tradition as the proper basis, or strict scrutiny, one of the two. So I think we're going to get a really good decision from the Supreme Court, all things being considered. But it's you know, we'll see what we get when we get it. But you know, I wouldn't bank on Chief Justice Roberts, but he seemed like he was asking questions that maybe, hopefully, he'll be on the right side of this. Red QWERTY says, will the Hughes amendments from Firearms Owners Protection Act, which bans automatic weapons, ever be overturned? Not in the near future. And then someone asked about woodchucks and Tupsy Pops, but I'm going to take a pass. Remember to subscribe, like, do all the YouTubey things. I'm going to head out. I'll be on the stream tomorrow with Nick. It's going to be a long day. I'll be there. Hope all is well, my friends. Till there, my friends. Cheers and goodbye.